All right, we are, the jury is not present in the courtroom at this time. Mr. Bach, you want to go ahead and call your witness? The court's going to conduct a jury out hearing with respect to portions of the witness's testimony there.
State calls Special Agent Joel Wade.
Do you solemnly swear the testimony you're about to give to be the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated.
Just briefly before we get going, sir, you're Joel Wade, Special Agent with the TBI.
Correct.
And I forget what it is now, but it used to be Technical Services Unit.
Now it's the Cybercrime and Digital Evidence Unit.
Okay. But basically, just for the purposes of this brief hearing, part of your job is you examine cellular devices and computers and the search to obtain usable evidence off those. Is that correct?
Correct.
Okay. Now, we're going to jump ahead in your testimony for the purpose of this motion. I asked you at one point, you were prepared for me to ask you at one point, did you also look at user named David's internet search history?
Yes.
Okay, and did you discover that the user logged into that account, visited sites that would indicate romantic interests outside of the home?
Yes.
Okay, and you tell us what sites these were.
Adult Friend Finder and Match.com. I'll pull those up real quick. Default. Give me 1 second. So we have in record 101, chat.adultfriendfinder.com.
What date was that accessed?
11/9/2011.
Did you have any earlier than that?
I have 11/7. For Match.com, it's a thumbnail image. There's another 11/9.
What site?
Adult Friend Finder.
What event number?
104 is the record number.
Judge, for purposes of the record, would the officer from the state line just stating what event number 104?
Well, there's 280 of these at least. Are we going to go through every single one?
Well, that's why I'm asking about the timing and the relevance also, and when. But we need to make a proper record, Judge.
I'm not sure I understand the 104 reference. Is that a self-assigned record number?
Yes.
Oh, okay. If he'll just identify the record number there.
Sure.
Okay. So moving down, 105 is Match.com thumbnails. It's 11/7/2011. All these times are still in UTC -6, so they're accurate times, local time for that date. Record number 106, Match.com. It's a thumbnail. It's going to be 11/7/2011, 8:10:44 p.m. Record number 107. It's a Match.com thumbnail image, and it's 11/7/2011, 8:10:44 p.m. Then another Match.com, record number 108. It's a thumbnail, 11/7/2011, 8:10:44 p.m. Record number 109, Match.com. It's an additional thumbnail. Date and time is 11/7/2011, 8:10:44 p.m. Record number 110, Match.com. Thumbnail. Timestamp is 11/7/2011, 8:10:44 p.m. Record number 111, Match.com. Thumbnail image as well, 11/7/2011, 8:10:44 p.m. Record number 112, Match.com. Thumbnail image, 11/7/2011, 8:10:44 p.m. Record 113, Match.com. Thumbnails. Timestamp is 11/7/2011, 8:10:44 p.m. Record number 114, Match.com. Thumbnails. It's 11/7/2011 at 8:10:44 p.m. Record number 115 is Match.com's thumbnails. Date is 11/7/2011 at 8:02:39 p.m. Record number 116, Match.com's thumbnails image. Date is 11/7/2011, 8:10:44 p.m. Record 117 is to the domain site of Match.com. The date is 11/7/2011 at 7:51 and 26 p.m. Record 118 is Match.com thumbnail. Timestamp is 11/7/2011 at 4:28:07 p.m. Record 119, Match.com thumbnail. 11/7/2011 at 4:28:07 p.m. Record number 120, Match.com thumbnail. 11/7/2011 at 4:28:23 p.m. Record number 121, Match.com thumbnail. 11/4/2011 at 1:14:22 a.m. Record number 122, Match.com thumbnail. 11/7/2011 at 8:10:44 p.m. Record number 123, Match.com thumbnail. Date is 11/7/2011 at 8:10:44 p.m. Record number 124, Match.com thumbnail. Date and time is 11/7/2011 at 8:10:44 p.m. Record number 125, Match.com thumbnail, 11/7/2011 at 7:53:04 p.m. Record number 126, Match.com thumbnail, date is 11/4/2011 at 1:14:40 a.m. Record number 127, Match.com thumbnail, 11/7/2011 at 4:27:45 p.m. Record number 128, Match.com thumbnail, date is 11/4/2011 at 1:13:57 a.m. Record number 129, Match.com thumbnail, date is 11/6/2011 at 10:34:45 p.m. Record number 130, Match.com thumbnail, date is 11/6/2011 at 10:34:45 p.m. Record number 131 is a Match.com thumbnail. Date is 11/6/2011 at 10:34:45 p.m. Record 132, Match.com thumbnail. Date is 11/6/2011 at 10:34:45 p.m. Record number 133, Match.com thumbnail, at 11/6/2011 at 10:34:45 p.m. Record number 134, Match.com thumbnail, 11/6/2011 at 10:34:45 p.m. Record number 135, Match.com thumbnail, date is 11/6/2011, 10:34:45 p.m. Record number 136, Match.com thumbnail, 11/7/2011, 7:56:40 p.m. Record number 137, Match.com thumbnail, 11/4/2011 at 1:01:43 a.m. Record number 138, Match.com thumbnail, at 11/4/2011, 1:01:43 a.m. Record number 139, Match.com thumbnail, 11/6/2011 at 10:28:31 p.m. Record number 140, Match.com thumbnail, 11/6/2011, 10:28:31 p.m. Record number 141, Match.com thumbnail, date is 11/6/2011, 10:28:31 p.m. Record number 142, Match.com thumbnail, date is 11/6/2011, 10:28:31 p.m. Record number 143, Match.com thumbnail, 11/6/2011, 10:28:31 p.m. Record number 144, Match.com thumbnails, 11/6/2011, 10:28:31 p.m. Record number 145, Match.com thumbnail, 11/6/2011, 10:28:31 p.m. Record number 146, Match.com thumbnail, 11/6/2011, 10:28:31 p.m. Record number 147, Match.com thumbnail, 11/6/2011, 10:28:55 p.m. Record number 148, Match.com thumbnail, 11/4/2011, 1:07:18 a.m. Record number 149, Match.com thumbnail, 11/4/2011, 1:07:18 a.m. Record number 150
I'm sorry, what day?
for 149,
Yes, sir.
11/4/2011, 1:07:18 a.m.
Thank you, sir.
You're welcome. Record number 150, Match.com thumbnail, 11/4/2011, 1:07:18 a.m. Record number 151, Match.com thumbnail, 11/4/2011, 1:07:18 a.m. Record number 152, Match.com thumbnail. Date is 11/4/2011, 1:07:18 a.m. Record number 153, Match.com thumbnail. Date 11/4/2011, 1:07:18 a.m. Record number 154, Match.com thumbnail. 11/4/2011, 1:07:18 a.m. Record number 155, Match.com thumbnail. Date is 11/4/2011, 1:07:18 a.m. Record number 156, Match.com thumbnail. Date is 11/7/2011, 7:53:04 p.m. Record number 157, Match.com thumbnail. Date 11/4/2011, 7:36:15 p.m. Record number 158, Match.com cookie. Date is 11/6/2011 at 11:31:59 a.m. Record number 159, Media Match.com, Matt Girls Webcams. Date is 11/6/2011 at 11:32 a.m. Record number 160, Match.com thumbnail. 11/4/2011 at 5:22 p.m. Record number 161, Match.com thumbnail. Date 11/6/2011, 10:44:50 p.m. Record number 162, Match.com thumbnail. 11/6/2011, 10:44:50 p.m. 163 record number, Match.com thumbnails. Date 11/6/2011, 10:44:50 p.m. Record number 164, Match.com thumbnail. Date 11/6/2011, 10:44:51 p.m. Record number 165, Match.com thumbnails. Date 11/6/2011, 10:45:52 p.m. Record number 166, Match.com thumbnail. Date 11/6/2011, 10:45:52 p.m. Record number 167, Match.com thumbnail. Date is 11/6/2011, 10:45:52 p.m. Record number 168, Match.com thumbnail. Date is 11/6/2011, 10:45:52 p.m. Record number 169, Match.com thumbnail. Date 11/6/2011, 1:45:52 p.m. Record number 170, Match.com thumbnail. Date 11/7/2011, 7:56:40 p.m. Record ID 171, Match.com thumbnail. 11/7/2011, 7:56:40 p.m. Record number 172, Match.com thumbnail. 11/7/2011, 7:56:40 p.m. Record ID 173, Match.com thumbnail. Date 11/7/2011, 7:56:40 p.m. Record number 174, Match.com thumbnail. Date 11/7/2011, 7:56:40 p.m. Record number 175, Match.com thumbnail. Date 11/7/2011, 7:56:40 p.m. Record number 176, Match.com thumbnail. Date 11/7/2011, 7:56:40 p.m. Record 177, Match.com thumbnail. Date 11/4/2011, 7:39:02 p.m. Record number 178, Match.com thumbnail. Date 11/4/2011, 7:51:19 p.m. Record number 179, Match.com thumbnails. 11/4/2011 at 1:20:33 a.m. Record number 180, Match.com thumbnail. Date 11/4/2011 at 1:02:24 a.m. Record ID 181, Match.com thumbnail. Date is 11/4/2011 at 1:01:24 a.m. Record 182, Match.com thumbnails. Date 11/4/2011, 1:01:24 a.m. Record ID 183, Match.com thumbnail. Date is 11/4/2011, 7:36:15 p.m. Record ID 184, Match.com thumbnail. 11/7/2011 at 7:51:26 p.m. Record ID 185, Match.com thumbnail. Date 11/4/2011 at 1:22:27 a.m. Record ID 186, Match.com thumbnail. Date 11/4/2011, 1:22:27 a.m. Record number 187, Match.com thumbnail. Date is 1/4/2011 at 1:22:27 a.m.
You say 11/4?
For 187?
Yes, sir.
187 is 11/4/2011 at 1:22:27 a.m.
Thank you, sir.
You're welcome. Record ID 188, Match.com thumbnail. 11/4/2011 at 1:22:27 a.m. Record number 189, Match.com thumbnail. Date 11/4/2011, 1:22:27 a.m. Record number 190, Match.com thumbnail. 11/4/2011 at 1:22:27 a.m. Record number 191, Match.com thumbnail. 11/4/2011 at 1:22:27 a.m. Record number 192, Match.com thumbnail. Date is 11/7/2011, 7:51:26 p.m. Record number 193, Match.com thumbnail. Date is 11/7/2011, 7:56:54 p.m. Record number 194, Match.com thumbnail. Date is 11/7/2011, 8:10:44 p.m. Record number 195, Match.com thumbnail. Date is 11/7/2011, 7:56:40 p.m. Record number 196, Match.com thumbnail. Date 11/7/2011, 7:56:40 p.m. Record number 197, Match.com thumbnail. Date is 11/7/2011 at 8:10:44 p.m. Record number 198, Match.com thumbnail. Date is 11/7/2011 at 8:10:44 p.m. Record ID 199, Match.com thumbnail. Date is 11/7/2011 at 7:56:31 p.m. Record 200, Match.com thumbnail. Date 11/7/2011 at 7:56 p.m. Record 201, Match.com thumbnail. Date 11/7/2011, 7:51:26 p.m. Record 202, Match.com thumbnail. 11/7/2011, 7:56:31 p.m. Record 203, Match.com thumbnail. Date 11/7/2011, 8:02:39 p.m. Record 204, Match.com thumbnail. Date is 11/7/2011, 7:53:04 p.m. Record 205, Match.com thumbnail. Date 11/7/2011, 7:56:54 p.m. Record ID 206, Match.com thumbnail. Date is 11/7/2011, 7:56:40 p.m. Record ID 207, Match.com thumbnail. Date is 11/7/2011, 7:56:40 p.m. Record 208, Match.com thumbnail. Date is 11/7/2011, 7:56:40 p.m. Record number 209 is a Match.com thumbnail. Date 11/7/2011, 7:56:40 p.m. Record number 210, Match.com thumbnail. Date is 11/7/2011, 7:56:40 p.m. Record number 211, Match.com thumbnail. Date 11/7/2011, 7:56:40 p.m. Record number 212, Chat Adult Friend Finder. View video file. Date 10/31/2011 at 9:09:31 p.m. Record number 213, Chat Adult Friend Finder. Date 10/31/2011, 9:09:31 p.m. Record number 214, Media Match.com cookie. Date 11/10/2011, 8:35:16 p.m. Record number 215, Match.com thumbnail. Date is 11/7/2011, 8:10:44 p.m. Record number 216, Match.com thumbnail. Date is 11/7/2011, 8:10:44 p.m. Record number 217, Match.com thumbnail. Date is 11/7/2011, 8:10:44 p.m. Record number 218, Match.com thumbnail. Date is 11/7/2011, 7:56:40 p.m. Record number 219, Match.com thumbnail. Date is 11/7/2011, 7:56:40 p.m. Record number 220, Match.com thumbnail. Date is 11/7/2011, 7:56:40 p.m. Record number 221, Match.com thumbnail. Date is 11/7/2011, 7:56:40 p.m. Record number 222, Match.com thumbnail. Date is 11/7/2011, 7:56:40 p.m. Record number 223, Match.com thumbnail. Date is 11/7/2011, 7:56:40 p.m. Record number 224, Match.com thumbnail. Date 11/7/2011, 7:56:40 p.m. Record number 225, Match.com thumbnail. Date 11/6/2011, 10:44:50 p.m. Record number 226, Match.com thumbnail. Date 11/6/2011, 10:44:50 p.m. Record 227, Match.com thumbnail. Date is 11/6/2011, 10:44:50 p.m. Record 228, Match.com thumbnail. Date 11/6/2011, 10:44:51 p.m. Record number 229, Match.com thumbnail. Date is 11/4/2011, 1:22:27 a.m. Record number 230, Match.com thumbnail. Date is 11/4/2011, 1:22:27 a.m. Record number 231, Match.com thumbnail. Date is 11/4/2011, 1:22:27 a.m. Record number 232, Match.com thumbnail. Date is 11/4/2011, 1:22:27 a.m. Record number 233, Match.com thumbnail. Date is 11/4/2011, 1:22:42 a.m. Record number 234, Match.com thumbnail. Date is 11/4/2011, 1:21:42 a.m. Record number 235, Match.com thumbnail. Date 11/4/2011, 1:21:42 a.m. Record number 236, Match.com thumbnail. Date is 11/4/2011, 1:21:42 a.m. Record 237, Match.com thumbnail. Date 11/4/2011, 1:22:42 a.m. Record ID 238, Match.com thumbnail. Date 11/4/2011, 1:21:42 a.m. Record 239, Match.com thumbnail. Date 11/4/2011, 1:22:42 a.m. Record 240, Match.com thumbnail. Date 11/4/2011, 1:01:43 a.m. Record number 241, Match.com thumbnail. Date 11/4/2011, 1:01:43 a.m. Record number 242, Match.com thumbnail. Date 11/4/2011, 1:20:45 a.m. Record 243, Match.com thumbnail. Date 11/4/2011, 7:36:15 p.m. Record ID 244, Match.com thumbnail. Date 11/4/2011, 1:22:27 a.m. Record ID 245, Match.com thumbnail. Date 11/4/2011, 1:22:27 a.m. Record ID 246, Match.com thumbnail. Date 11/6/2011, 10:45:52 p.m. Record ID 247, Match.com thumbnail. Date 11/6/2011, 10:45:52 p.m. Record ID 248, Match.com thumbnail. Date 11/6/2011, 10:45:52 p.m. Record ID 249, Match.com thumbnail. Date 11/6/2011, 10:45:52 p.m. Record ID 250, Match.com thumbnail. Date 11/6/2011, 10:45:52 p.m. Record ID 251, Match.com thumbnail. Date 11/4/2011, 1:01:24 a.m. Record ID 252, Match.com thumbnail. Date 11/4/2011, 1:01:24 a.m. Record ID 253, Match.com thumbnail. Date 11/4/2011, 7:36:15 p.m. Record ID 254, Match.com thumbnail. Date 11/7/2011, 8:10:44 p.m. Record ID 255, Match.com thumbnail. Date 11/7/2011, 8:10:44 p.m. Record ID 256, Match.com thumbnail. Date 11/7/2011, 8:10:44 p.m. Record ID 257, Match.com thumbnail. Date 11/7/2011, 8:10:44 p.m. Record ID 258, Match.com thumbnail. Date 11/7/2011, 8:10:44 p.m. Record 259, Match.com thumbnail. Date 11/7/2011, 8:10:44 p.m. Record 260, Match.com thumbnail. Date 11/7/2011, 8:10:44 p.m. Record 261, Match.com thumbnail. Date 11/7/2011, 8:10:44 p.m. Record number 262, Match.com thumbnail. Date 11/4/2011, 5:22 p.m. Record ID 263, Match.com thumbnail. Date 11/6/2011, 10:28:31 p.m. Record ID 264, Match.com thumbnail. Date 11/6/2011, 10:28:31 p.m. Record ID 265, Match.com thumbnail. Date 11/6/2011, 10:28:55 p.m. Record ID 266, Match.com thumbnail. Date 11/6/2011, 10:28:31 p.m. Record ID 267, Match.com thumbnail. Date 11/6/2011, 10:28:31 p.m. Record 268, Match.com thumb. Date 11/6/2011, 10:28:31 p.m. Record 269, Match.com thumbnail. Date 11/6/2011, 10:28:31 p.m. Record 270, Match.com thumbnail. Date 11/6/2011, 10:28:31 p.m. Record 271, Match.com thumbnail. Date 11/6/2011, 10:28:31 p.m. Record 272, Match.com thumbnail. Date 11/4/2011, 1:10:42 a.m. Record ID 273, Match.com thumbnails. Date 11/4/2011, 1:10:42 a.m. Record 274, Match.com thumbnail. Date 11/4/2011, 1:14:22 a.m. Record 275, Match.com thumbnail. Date 11/7/2011, 7:56:40 p.m. Record 276, Match.com thumbnail. Date 11/4/2011, 7:36:15 p.m. Record 277, Match.com thumbnail. Date 11/4/2011, 1:14:40 a.m. Record 278, Match.com thumbnail. Date 11/4/2011, 1:09:50 a.m. And record 279, Match.com domain. Date 11/7/2011, 7:51:26 p.m.
And is that all of the dating sites that were accessed
Correct.
during the relevant time period?
During that time period, yes.
That's the end of my examination for the purposes of the motion, Your Honor.
Can I ask some questions?
Related to these records,
Yes, sir. You examined the laptop.
Correct.
This is the laptop from the house.
Correct.
That was the extent of your knowledge of it.
Correct. Yeah, that's all that was on the property receipt as far as where it was located.
The local, I guess, Dyer County Sheriff's Department sent it to you for examination.
Incorrect.
How did that work?
It was the VCRT, our Violent Crimes Task Force, was asked to come out and assist in processing the house pursuant to the search warrant that Nation Bishop had issued and got signed. And from there, the Violent Crime Task Force collected evidence and brought that to me.
So it was, as a result of the search warrant, this laptop was received by that team, and the team conveyed it to you.
Correct.
Was it the only laptop in the house?
No.
Okay. And to your knowledge, you don't know what room the laptop was located in when it was
I've never
seized?
seen the house,
Okay.
sir.
And you don't know if it was a common laptop that was used by the people in the house, different users?
The user that was established in this was David, and it was password protected.
Did you establish other users that are listed on the?
There's not any other users outside of the local administrative accounts that are built into the operating system.
So it could possibly be a laptop that's being used that other people are using as password. Is that possible?
If the password is shared, it is possible, yes.
Yeah. And is that sometimes common in households if there's one laptop or a laptop for common usage?
That is possible, but there again, this one was password protected and it was changed on 10/24.
Okay. 10/24.
The password was changed. Would you like to see that artifact?
But you don't know if there were other people living in the house that possibly knew the password.
I don't know that, no.
Okay. It's possible, though.
Sure, it's possible.
You just know what you see on the site.
I know what account was logged in and what was accessed through that particular account.
Now, these Match.com thumbnails, what's the difference between a thumbnail and just looking on a site?
So all this is in private browsing, which is different than just browsing over the regular domain. So they've made a step to try to protect their browsing history, whoever was viewing it. And so when you load that initial page, all those images get cached. So that's why when I read through a lot of those, it was the similar timestamp, because that was when that image was viewed.
Okay. But just from looking at it, if people are sharing a password, it's possible that more than one user had it.
It's possible.
Access to sites.
It's possible.
Now, if the divorce occurred October the 10th, 2011, what you have on here is after that date. Are these after October the 10th, 2011?
It starts at October 10th, 2011 and goes to 11/14, which is when we took possession of it.
Okay. So it started the day of October the 10th, 2011?
Correct.
Okay. And it continued until, what was the last date?
The date that I took possession of it was 11/14/2011, so that's the date that I ran it through.
But the last of these events?
I would have to
Yes, if you need to.
filter and give you the last date.
The start and the end. So you're saying it October.
The earliest was 10/31, and I believe the latest was 10/7 without filtering on date.
10/7 or 11/7?
11/7, sorry, sir.
Okay. So you're saying 10/31 through 11/7?
Is that date range for these websites.
Okay. What did you say about October the 10th, 2011?
That is that time frame
Yeah.
window for the search for this particular work product.
Okay. All right. Now, let me just make sure I'm almost finished. You did a lot of reading, and I appreciate that. A thumbnail versus a data, what's the difference?
I don't think I understand your question.
You explained what a thumbnail is.
A thumbnail is a cache version of the image.
Does that mean clicking on it, or
So as soon as you hit the site, it's going to cache that thumbnail. If you click on it, it's going to cache multiple versions of that image.
Okay. Now you said something about a cookie.
Cookie is, so those are artifacts that allow you to go back to that site readily quicker. So it kind of remembers your settings and versus things like that.
Okay.
Most websites use those because they want to target their audience.
Now let me make sure. I guess from October the 10th, 2011, you examined these are all dating sites. That's what you read, this long list.
I didn't hear your question.
These are all dating sites, what you term as dating sites.
Correct.
Okay. The prosecutor asked you to read all the dating sites, and that's what you just read, right?
Correct.
And you're saying that the access to this dating sites started when? On what date?
10/31. For this time frame, we're only looking at a snapshot of the entire computer. So if we were to look at the totality of the computer, we may find more, we may find none.
All right. Let me just ask, did you look at the time frame from October the 10th until your first event on this?
Correct.
Dating sites?
Correct.
All right. And did you identify any then?
That popped up was 10/31 was that time frame.
The first one? Yes or no?
Yes.
Okay. That's all the questions I have for him, Judge.
I don't have any further questions. The chain of custody, Your Honor, Agent David Howell, the TVI, testified Friday. We admitted into evidence a picture of the laptop that he personally recovered. and had it transported to TSU, where it became in the custody of Joel Wade. I believe the serial number from that gateway. So if there's any question about what he examined, that's already been established by the proof.
I think the motion to exclude does not encompass the chain of custody.
Okay, I was just making sure.
Yeah. Okay, I'll hear you, Mr.
Judge, do we need a witness in here?
I need you to get to a microphone
Yes,
so I can hear you.
I guess, do we need the witness present, Judge, or?
I don't think it makes any difference.
Okay. Yes, sir.
In this instance, this is an admissibility question, not a content issue.
Yes, sir. Judge, for the record, I state my objection for the following reasons. We did file a motion in limine. We did file a motion under 404 and 608. It's been filed several months ago. In addition, we have issues of relevance that we're concerned about. There is some computer data that is on this that we did receive, and this case has been going on for I guess since 2022, and I came into it sometime after, several months after he was indicted. We did receive discovery material. We received these searches. I want to state this for the record because I stated it on May the 14th when we were last in court, and I made the court aware and raised the issue that we had been told that there was forthcoming discovery material in the form of all of these web browser searches. And I informed the court that we had not received these and that we were going to object to it. And we needed time to review this with our expert. And we were informed on May the 14th, the state indicated that they would convey that to me. And we can go back and look at the record. I know Your Honor probably remembers that they would give it to me that day. And we left that day and we asked, and we did finally receive on May the 17th a downloaded version on some media on a disc. So we had it about 4 p.m. on May the 17th, these web browser searches. That was on May the 17th. And so we've had it during that time. And I made the court, I think, when we first started this case, we started this trial on May the 28th, aware that we had received that and that I needed my expert to look at that. And we have done our best to meet the time frames and to be ready, but we did receive that, and I object to the admissibility of this so late. And the other thing is these are searches, and I would say this, you heard from the questions I just asked the agent about, is it possible other people use this? And he indicated that it is possible that if they knew the password, it could be. You can imagine a situation, or it could be testimony that other people besides David Swift use this laptop. The agent just knows what he sees on the search. I would point out that for relevance purposes and prejudice purposes, the divorce was October the 10th, 2011. She filed for divorce. She left for a week. She's gone, but she comes back. They are in the house, but the divorce is still ongoing. She's gone on October the 30th of 2011. It's not apparent that it's a murder. It's not apparent. It could be that she's gone. She just left. And as far as that's the information, you heard the interviews of David Swift. She's gone. I don't know where she is. If there are web searches after that date or before that date, how is that relevant to who killed or things of that nature? It doesn't show anything other than trying to prejudice the jury against Mr. Swift. Now, if there were web searches or browser searches, how to clean up after a murder, how do you kill your wife and get away with it, how do you do this or that promotes some act, and that would be relevant. This is none of that. This is somebody going on and looking at dating sites. Now, what does that really prove? What does that really prove? It doesn't prove that he killed her. It's used as to prejudice the jury against him. And to be honest with you, Judge, there's issues of sometimes people are married. Sometimes people look at sites, whether they're married or not. There's obviously some things going on in this marriage that are non-traditional, shall we say, on her part, and perhaps, but even if he did look at a web search, even if he did do that, what proof is that he killed her or had a motive to kill her or got some information to further a possible killing? So I object to it. It's speculative. It's being introduced to prejudice Mr. Swift in the eyes of the jury. I would point out that it's possible that other people had access to the computer in the house, and because of the late notice, we also object. 404, 608, other acts. What other act is this? It's not a criminal act. It's not a bad act. It's somebody looking on sites at information. Two people could be married, but they both look at dating sites even though they're married. Does that mean that they killed somebody or that they had a motive to kill somebody? I've seen studies, and we can use our common sense, that people sometimes, even married people, look at sites that are of this nature. And does it mean that they had a motive to kill or to do anything? For the reasons, all these reasons I've stated, I object to this. I object to the late notice. I object under 404 and 608. I object to keep, this jury's been here for a while. We need to hear relevant evidence that proves that David Swift committed a murder. That's the burden the state has. This testimony does not do that. It shows that somebody looks at sites. If I'm looking at sites of Civil War sites or something, or if I'm looking at lawyer sites, how does that really prove it? What's the difference with dating sites? She's filed for divorce. She's indicated she doesn't want to reconcile. He's gotten a divorce lawyer, and so before she's gone, and he knows that she's wanting to divorce him. So how is this relevant? Even if he did look, it doesn't mean he did anything to date somebody. It doesn't mean he carried any act. But I submit that it doesn't establish motive. It doesn't establish anything other. It's irrelevant, and I object to it.
Okay, let me hear from the state.
You know, the defendant's state of mind is always relevant. And the state's position in this is, no, it doesn't absolutely prove that he killed her. But it's very interesting to note that he accepted service of the divorce on October 10th. The visits to the dating sites didn't begin until 24 hours after she went missing.
Okay, well, let's stop right there and take that. For what purpose, then, are these dating site searches offered? I mean, what's the purpose of
the purpose is, Your Honor, the state should be allowed to argue the inference that within 24...
That's what I want to know. What is the inference that the state wants the jury to make from this?
The inference is, Your Honor, that within 24 hours of his wife going missing, he is hot and heavy on dating sites.
So
he knows she's not coming back. He didn't get on them when the divorce was first filed. He waited until she was disappeared.
It's the guilty knowledge.
Yes, sir.
Really, you want the jury to infer guilty knowledge from these searches.
Well, and, you know, Judge, the jury has heard him tell the investigators, I want her to come home. I just want her to come home. In both of those interviews, Yet, at the same time, he's engaged on the October 31st adult friend finder. He's actually chatting with somebody looking for an outside relationship. The jury should be able to hear that he had moved on, that he was not concerned. He was certainly not concerned about his continued relationship with Ms. Swift, and they are entitled to wonder why. Now, as far as the lateness of this, Your Honor, the defense was entitled to examine this computer at any time they wished. All they had to do was file a request. It's going to be just like the state or the defense's tire expert who's going to claim, well, the tire wasn't available for inspection. Well, they never asked for it. So what the defense is actually complaining of, Your Honor, is that we kept probing the evidence available and found that there was a newer tool that was available that we could extract more information from the evidence that had been. If the defense wanted to examine this item, they could have time, and their expert would have found the same thing that our expert did. Now, and talk about the burden upon them. We did. As soon as we found out about it, we conveyed that to them. We tried to get it to them. We got this information. At first, it was tried to email to us. It was too large for email, so we had to get a thumb drive overnighted. We tried, again, to email. We tried different ways to email the defense. We had to overnight them a thumb drive. So we did everything we could as soon as it was in our possession to get it to them. We did that. But I submit that ultimately, Your Honor, as far as the lateness of it, it's the defense's own problem because they didn't ask to examine evidence that was available to them. And, no, I think I've said that.
Okay.
Judge, can I say just one more?
I think court's ready to rule.
But Judge, for the record, can I say one thing? I will be very brief.
I'm ready to rule. I don't know what you need. I don't, go ahead. I've heard from you. I've heard from them. Go ahead, though, Mr. Taylor.
And I'm just trying to do my job, Judge.
I understand that, but you only have to do it once.
Yes, sir. I would point out, they said it should be relevant for motive to show guilty mind because he started searching after she left or after speculation because she's filed for divorce. Going to reconcile. We've heard that in the proof. She's gone. He doesn't know. He told the officers in the interview that the state played, I don't know where she is. I don't know if she ran off. How does that prove that he had knowledge of it? And maybe it was a realization that she's gone and it ain't going to work. And he just starts looking online. So I would just point that out. I think it requires speculation. You're asking the jury to speculate. It is not conclusive that it shows guilty mind. It may show that she moved on. And I appreciate you listening to me, Judge.
Yes, sir. First off, there are other results of the examination of the search or drive of the computer that the state's already agreed it will not attempt to introduce in front of the jury. Is that right?
Yes, Your Honor.
And those would be, and I'll tell you, I can look at the agent's computer screen and see what else is there. Pornography URLs. I assume that's the information that you're not going to attempt to introduce.
That is correct, Your Honor.
Okay.
Or be displayed in front of the jury during this.
I wonder if there's a way to delete that, both that and anything else that the court may exclude here.
And Judge,
We need to make sure the jury doesn't see that.
Since the state said that, and is there anything else for relevant purposes so we'll know now that we can make it easier? We don't have to come back and have another jury. Anything more relevant on the computer that's going to be introduced for relevance purposes?
Well, certainly there is also going to be testimony that night around 3:30 in the morning, the defendant plugged in an external device to his computer and was viewing a large number of pictures. Now, one of those has already been disclosed from our supplemental report, which the defense has had for years. These two pictures were accessed from an external device.
Pictures of the victim's tattoo?
Yes, sir.
Right, and they're already in.
And then also, shortly thereafter, he accessed an external device, which he's unable to tell if it was a digital camera or a cellular telephone. But the state will submit, or the state's going to argue after we see the pictures, that a large number of the pictures on there are of landscaping jobs. And so the state, in closing, will argue that the inference is that was Miss Swift's iPhone that the defendant was accessing at 3:30 in the morning. The photos are all of the children, sporting events. I cannot recall there being a single picture of the defendant on there, but there are, if I remember correctly, 28 pictures of landscaping events. And certainly that is relevant, Your Honor, because if the defendant is accessing the victim's iPhone at 3:30 in the morning when he claims he's asleep, the state should be able to explore that.
Okay. We'll, if there's an objection to that testimony, I think we can take that up as it develops. The defendant has moved to exclude testimony or other proof at trial of the defendant's activities on the internet in the days up to, I showed the last date. There was one file from November 10. I don't know who that is. That's the one I show as the last time. Anywhere from October 31 to November 10, and we're speaking specifically at this point about the files that have been identified thus far as the TBI file number assigned to it 104 all the way through 279. Those appear to be the matters at issue before the court. So that activity on the internet as revealed by the search there, although the defendant has expressed some concern about the late production of the search results, court tends to agree with the state here in that the defendant could have made the same examination of the computer files at any point during the pendency of this case. The defendant has not requested a continuance of the case in order to do further research on that. So that's really not the court's problem. In order to determine whether or not this evidence is relevant, though, the court has to first determine whether the evidence has any probative value for the jury. The state asserts that the evidence tends to demonstrate guilty knowledge by the defendant. And assuming for a moment that the evidence has that probative value, the court's got to determine again whether the probative value is substantially outweighed by the danger of unfair prejudice, and if not, whether there is a material issue under 404B other than action in conformity with the character trait or the action, however that denominated. I don't think the evidence is prohibited by 608 at this point because there can't be a credibility attack until the defendant has testified, and so it's not admissible under Rule 608. If there's some material issue under 404B other than the defendant's action in conformity, then again, is the probative value, if there is any, is it outweighed, not substantially outweighed like there is in 403, but is it outweighed by the danger of unfair prejudice? So what is the act or character trait sought to be communicated here by these activities? The state wants to prove that the defendant was looking for a girlfriend within several days, within one day up to almost 2 weeks, not quite 2 weeks, maybe 11 days after the disappearance of the victim, with the logical deduction or the inference that state wants the jury to draw is that the defendant knew that the victim was dead and that he could only know that because he had killed her. That's the inference that the state wants the jury to draw from this information. So it's a bit of a reverse. The state wants to show this activity to demonstrate that the defendant had acted in conformity with getting on Match.com and AdultFriend.com and whatever other sites were represented there, to demonstrate that he knew that. 404B prohibits the introduction of a character trait, evidence, or other acts of the defendant in order to demonstrate that he acted in conformity with the trait or the activities. So if the evidence is designed to demonstrate that the defendant must have killed the victim because he was looking for a girl on the internet at the time when, if innocent, he should not have been doing that or could not know that his wife was deceased, then the evidence is required to be excluded because its purpose is to demonstrate that he had acted in conformity with that activity, that he had acted before, that is, that he had killed his wife, and this activity shows that he had done that his actions had conformed with this internet search. One other thing, there may be different explanations for the activity on this end. I don't know what the explanation might be for the pornography sites, and this activity, if correct, may be in extremely poor taste, but it could be that the defendant may have been looking to see if his wife had a profile on a dating site, or if there was another potential suspect who may have contacted her through that site. I don't know. But we're asking the jury to make some guesses here, and we're asking the jury to pick one of, choose a reason for him to be on there. And so because of that, the court thinks that there is the high likelihood of confusion on the jury's part. So references to the activity that is represented by files number 104 through 279 is going to be excluded. And to that degree, the motion is going to be granted there. Are we ready for the jury?
Does that include, should the defendant testify, that we are prohibited from cross-examining?
That would change the applicable rules.
Yes, sir.
And would also change the court's analysis.
Yes, sir.
Okay. This applies, I'm sorry, to the state's case in chief. Okay. All right. Are we ready for the jury?
Yes, sir. Yes, sir.
If they're ready, I'm ready. When they come in, sir, I will remind you that you've previously been sworn. I just like to do it in front of them so they know. No problem.
All rise.
All right, let's be seated. Good morning to all of you. Well, first, I owe you an apology. We've kept you back there for almost an hour and a half. I'm going to have to take the blame for that. You could have slept another 30, 45 minutes or an hour, and I accept the responsibility for that. I did not make the connection on Friday when we parted that we may have to do this morning without you. So I'm sorry for that. Let me ask all of you first, everybody feeling good? We got everybody here this morning. During the weekend, did anybody discuss this case with anybody else? I understand that one of you, and I don't need to know who it was, one of you had just an attempted contact from a friend wondering whether the trial was over, and you didn't respond to it. And whoever it was, thank you for being that careful about it, because responding to it might have started a conversation about it. And I appreciate that very much. Did anyone attempt to contact any of you over the weekend to discuss the trial? Okay. Did anybody visit any location mentioned last week at all? Did anybody review any video footage or streaming or anything else connected with the trial? I want everybody to tell me yes or no. Okay. Did anybody give an interview to any media person? No. Did anybody post anything on an internet site or social media? No. Did anybody do any additional research of any kind? No. Thank you all so much. I appreciate the integrity that you had about this over the weekend. All right, Mr. Box.
State Call Special Agent Joel Wade.
Sir, you have previously been sworn. Okay. All right, sir. Thank you.
All right, so you are Joel Wade.
Correct.
And you are with the Tennessee Bureau of Investigations?
Yes.
And what is your position with the Bureau?
Special agent.
What unit in the Bureau are you at?
Cybercrime and Digital Evidence Unit, previously the Technical Services Unit.
Okay. And what are your duties in this position?
At the time, I was a digital forensics examiner. Now I currently am in communication intelligence, where I assist in locating missing persons.
Okay. And how long have you been in that position?
Since 2007. I've been with the Bureau since 2005. Was promoted to Special Agent in 2007 and have been in that unit ever since.
Okay. And in layman's terms, what does your job entail?
At that time, we would take in any digital evidence that came in, whether it be a computer, a hard drive, a thumb drive, flash media from a camera, a USB drive, compact disc, DVRs, video cameras, all such things like that, to include cell phones. It progressed where we would take in drones, anything that's going to have a digital footprint that a user could create. We have some sort of ability to analyze that.
Okay. And what is your educational background, sir?
I have a Bachelor's of Science in Psychology with a minor in Sociology from Tennessee Technology University out of Cookeville, and a Master's of Science in Criminal Justice from University of Tennessee at Chattanooga.
Okay. Do you have any certifications pertinent to your current position?
I have over 1,800 hours of specialized training in computer analysis, to include CompTIA A+ training, as well as D-Step and SCRS certified through FLETC. The D-Step course is the Digital Evidence Acquisition course, so that's where we learn how to take the evidence from a computer, plug it up to the right blocker so that we don't make changes to that, and then image that piece of media, regardless of whether it's a hard drive or it's a thumb drive or the like. And then the seized evidence recovery program, or SCRS, is where we learn to analyze that, use the tools that we can use to analyze that. Then I have in-depth certification, which is mobile device investigation program through FLETC as well. And that allows us to learn the different operating systems that a cell phone would have, from your feature phones that are typically proprietary or a Brew type operating system, all the way to Android and iPhone, and then in this particular case, BlackBerry's proprietary operating system by RIM.
Sir, can I, if you will, you clear your screen?
Sure.
Your screen's going on our screen. Right, thank you. Go ahead.
Agent Wade, I imagine this is a rapidly changing field. How do you stay up to date with technological advances?
I attend conferences. I do peer review article analysis. I am an adjunct professor at Cumberland University, Lebanon, Tennessee, where I developed and teach digital forensics and mobile forensics courses.
Okay, have you previously testified in court as an expert?
I have.
Do you recall how many times?
Roughly 17 times.
Mr. Taylor, you want to ask some questions about?
Just briefly, because I hadn't met the agent before. Agent, let me ask you, the 17 times you testified before, has it been Tennessee State Court or other jurisdictions?
All Tennessee state courts.
Has it been in preliminary hearings or circuit court, or?
It's been a variety of those. Some of them have been motion hearings, some of them have been in an actual trial.
And did you attend an actual digital training school?
Yes, I've attended several digital training schools. So FLETC is the Federal Law Enforcement Training Center, where I got those 3 certifications, and then I've been through numerous programs through vendor certifications, as well as tool agnostic programs where we learn, ISP, which is in-system programming. We're touching the board with probes to identify different taps, then all the way to chip off, where we're taking the memory chip off of a board to then put it into a reader to read it like we would any other thing.
Right, I understand. Now, the first thing that you said you attended, you used an acronym. I just want to make sure that we all understand.
Yes, so
you attended.
DSTEP is Digital Evidence Acquisition Program, and so that's through the Federal Law Enforcement Training Center in Glencoe, Georgia.
Okay. And did you mention any other acronyms?
SCURS, Seized Evidence Computer.
Okay. If you'll explain it.
Yes, so it's Seized Computer Evidence Recovery Program, and that's where we go through and do the analysis once we've acquired it with the tools that we learned in DSTEP, or Digital Evidence Acquisition Training Program. We take that knowledge, apply it, and use the tools to create the work products.
Just a couple more questions. The first school you mentioned at the Federal, how long was that?
2 weeks.
Okay. The second school that you mentioned, what was the name of it? How long did it
SCURS,
first?
it was 2 weeks.
And any others?
They vary from a week to 2 weeks. Then some are, you take a class for that week, then you continue along where you're working on the evidence, and then you get proctored at the end.
All right, so the FBI would be a 2-week school with the federal school?
The federal school is a 2-week school.
And then the next school was this, you say SCURS?
Correct. It's at the same facility.
Right.
It's just it's a building block, right? So the first one only allows you to image the evidence, right, to create that forensic image so that there's no changes made to the data. The next allows you to learn the tools and the skill sets and all the scripts to analyze the data.
In addition to those two, have you been to any other schools?
Yes, I've been through FTK. I've been through FTK.
What does that mean?
It's Forensic Toolkit. It's gone through several different buyouts. External currently owns it. I've been through Magnet.
And how long was that one?
Each of the, so that was a series. It was a boot camp series. So I had a whole year to take roughly, 20 plus courses.
Okay.
So anything from Windows artifacts to registry artifacts, where we're looking specifically at the registry inside of the computer.
Okay, I'm almost done. Are you required to update with updated technology training each year?
I have because of my academic stance, I have to maintain continuing education credits every year, yes. And then the Bureau requires us to maintain that as well. There's not a standard in the policy, but anywhere from 40 to 80 hours every year I have attended.
All right. What is your mandatory attendance requirement?
40.
Okay. Thank you.
Terry Crawford, the witness is an expert in the fields of mobile device and computer forensics.
Mobile device and computer forensics.
Yes, sir.
Mr. Taylor, you have any objection?
No, Your Honor.
We'll accept the witness as an expert in the area of mobile device and computer forensics.
Agent Wade, in your capacity as a special agent, were you ever asked to examine evidence relating to the murder of Karen Swift?
Yes, I was.
Okay. Did you prepare reports as the results of your examinations?
Yes, I did.
And did you bring them with you today?
I did.
Okay. Tell us how you first became involved in this case.
Special Agent Nation Bishop had created a search warrant at the request of Dyer County Sheriff's Office to assist in an investigation, and the violent crime response team was called out. They deployed, that team collected the evidence at the residence, and from there, Kevin Warner brought that evidence to me on 11/14/2011.
Okay. And is it normal procedure for the TBI, or of the TBI, for seized items and searches to come into your possession for analysis?
Correct. At that time, there were no digital forensics examiners in Jackson that were fully trained.
Okay. Did you examine all the items Agent Warner provided to you?
Correct.
Okay. Were all of them, did they all provide useful evidence to you?
Not all of them, no.
Okay. Can you tell us why some of them may not have?
Some of the digital camera cards were outside the scope. They were pictures from 2007 to 2010, so did not apply to the scope of the investigation. A couple of the cellular phones, the batteries were swollen, so even when I applied power to the device, to a power supply, it was not enough to bring the phone back to life, if you will, in order to examine it.
On Friday, Agent David Howell, are you familiar with Agent Howell?
I am.
Okay, Agent Howell testified that during the search of the 65 Willie Johnson Road property, that he personally took possession of a Gateway laptop, serial number, and it's very long, but it ends with 91601, and brought it to the Technical Services Unit for processing. Did you perform a forensic examination of that Gateway laptop?
Yes, I did.
Okay, can you describe the process you used to perform that extraction?
So with laptops, typically when they come in, and in this case when they came in, it was powered off. So we remove the battery from the laptop, then we take off the bottom plate to remove the hard drive from the laptop. Once the hard drive is removed from the laptop, then I place that hard drive behind a piece of hardware that is a write blocker. So what a write blocker does, it allows me to have a stopgap, right? I can read the data, but I can't make changes to the data. When that is plugged up, then I can create a forensic image of that particular hard drive. Once that forensic image is created, then a computer mathematical algorithm number or a hash value is created, kind of like a fingerprint, so that we know that that computer image has not changed. And then we verify that image hash value at the end of our analysis.
Can you describe the types of data you obtain from such an extraction?
So on laptop computers, obviously you're going to have email, you're going to have pictures, videos, documents. You may have tax documents or privileged information from lawyers or whatever. You also will have internet activity and different things in the registry as far as programs that got installed or removed, various things like that, etc.
Okay, and after you originally performed an analysis with the computer, did you perform another analysis?
I did perform an updated analysis using a newer version of IEF, which had then been rebranded as Axiom,
And what was the purpose of that updated analysis?
to be able to look at the data in its totality. There were more artifacts that were being able to be processed at that time.
Layman's terms, you could see more things?
Correct.
When you were examining this computer, did you focus on a specific time frame?
I did from 10/10/2011 to 11/14/2011, because that's when we took possession of it.
Okay, and what's the significance of the 10/10/2011 date as a start?
My understanding is that when Mr. Swift was served with process.
Okay. We've heard previously in the trial, the defendant tell officers he went to sleep on October 30th, 2011, shortly after 2008, and slept until around 10 o'clock that morning. Did your examination of the gateway?
I don't object to leading. He can ask the question.
I don't believe it's leading. I think it's setting the foundation for the question. So objection to be overruled.
Did you hear let me repeat my question?
Please.
Okay. We heard earlier in the trial the defendant tell officers that he went to sleep shortly after 2:08 a.m. on 10/30/2011, and he slept until around 10 o'clock later that morning. Did your examination of the gateway computer reveal anything that would call the truth of that statement into question?
There were internet searches and activity where devices were plugged into the computer at that time, yes.
Was there anyone logged on to the computer?
The user account David was logged on.
Okay, and can you tell from your examination if logging on with the username David required a password?
It did.
Okay, and were you able to tell what the account logged into was viewing during that time frame?
It had gone to yahoo.com and then immediately started looking at pictures from a removable device.
Okay, when you say a removable device, does that have another name?
So it's digital camera images is the folder structure, but it's going to give it a drive letter that's not typically associated with like the operating system drive. It's typically drive C, right? The user can go in and change that, but typically in the install it's drive C. So when you plug anything into the computer, it has to give it a drive letter. It's not going to give it the same drive letter, or otherwise you'd have conflicts, right? So this one is drive letter E. It could have been F, right? But in this it is E.
When you see DCIM folders, there are external devices you typically associate those with?
Digital cameras, right? So it could be a Canon digital camera or a Kodak, EasyShare, but it also can be a cell phone because we have digital cameras on our new cell phones.
Were you able to see whether or not the defendant was viewing any images of what appeared to be a female at around 3:13 that morning?
Correct.
Okay.
Which exhibit are those copies of? Do you know, sir? Which exhibit are those?
They're not an exhibit yet, Your Honor. I'm just asking if he recognizes them.
Yes, I did.
Okay, can you tell us what those are of?
It's a picture of a tattoo, which would appear on the right side of this individual's body. And
Okay.
it's a second version of that, but the hand placement is different.
Okay. And do you have a time that the defendant was accessing those pictures on the gateway, or the username David, let me be clear, the username David was accessing those pictures?
I do. I need to pull it up to recall them.
Okay.
It was accessed on 10/30/2011 at 3:13:34 a.m.
Okay. Is there another one?
The second picture was accessed at 10/30/2011 at 3:13:41 a.m.
Okay, and so at 3:13 on October 30th, was that the only time the username David accessed these tattoo codes?
No.
Can you tell us when?
Let me go with that. So these are in UTC. I misspoke. Yes, it is the only time for those instances.
Explain, we're seeing 8:13 a.m. on
So
there.
this report was the supplemental at the request of the Dyer County Sheriff's Office, and at that time I did not convert from UTC to UTC -6, or in this instance it would be UTC -5.
So what was the local time?
Local time here would have been 3:13:41.
Have you checked the Internet Explorer weekly history on this?
So then we have 10:30 at 3:13:02. If you'll look back, just so you have the file name reference, file name is 101_1624 and 101_1626. If we look at the weekly history for 101:1626, there was 10:30 at 3:13 in the morning. Then you've got 24 at 10:30, 2011 at 3:13:44 in the morning. Then you have 101_1626 at 10:30, 2011, 3:13:02 in the morning. And then you have 101_1624 at 10:30, 2011, 3:13:44 in the morning.
Okay. Would you make those pictures of exhibit to your testimony?
Yes.
Vehicle is 33. They haven't been identified. I know we've seen them earlier. I don't think they've been even identified.
I think at this point, Your Honor, the only identity is they are pictures that were on the gateway seats from the house at 65 Willie Johnson.
I thought they were admitted as 19.
Well, there are pictures. I would object them being introduced as an exhibit at this time. They can be introduced as ID purposes. But if you can't, there is one earlier. If they're different.
They're two photos.
There is another photo that has been introduced of that same tattoo, Your Honor. These photos are being introduced for the purpose of showing that username David was accessing them at a time when he claims to be asleep.
And these are different from number 19.
I think one of them is the same, Your Honor.
Okay. Well, the court's going to admit the two photographs as Exhibit 33.
All right, Agent Wade, did the username David access any other photos that morning
Yes, he did.
around 3:30 a.m.?
Correct.
Okay, can you scroll down for those for us?
So we have some, looks like kids' soccer photos. There again, still around the 10:30, 2011, 3:30. Again, picture of a Volvo sedan. Back to some kids' soccer activities. Still within that 10:30, 2011, 3:30 time frame.
Can I stop you for just one second?
Sure.
Now, it appears that all of these pictures have almost the identical timestamp on them. They may vary a second or two. Can you explain to the jury why that is?
So when a device is loaded in, right, when we insert a thumb drive or some other removable media into the computer, a lot of times it auto defaults for that window to pop up for File Explorer, and it's starting to display all those images to us. So that's why those created access timestamps are all very similar, because it's the processor of that computer is displaying multiple images at once.
So would it be fair to say, for example, if an iPhone were plugged into a computer and their photo gallery was accessed, would that account for the same time?
Correct.
On all of these? Please continue.
Now there's a picture, it looks like maybe a prom or a dance, still about the same time frame, 10/30/2011, 3:30, 14 a.m. Sorry. Some cheer competition pictures, still around the same time frame, 10/30/2011, 3:30, 15 a.m. Still looking at pictures. We've moved to 10/30/2011, 3:30, 18 a.m.
Matter of seconds later. Is that correct?
Correct. Now we're into 10/30/2011, 3:30, 19 a.m. Back to some school activities, soccer. Some beach pictures or playing at a park. We're at 10/30/2011, 3:30 and 23 a.m. Sorry. Now we're at 20, October 30th, 2011, 3:30, 25 a.m.
Please continue. Okay, now slow down on these.
This is a picture of side of house with some landscaping. 10/30/2011, 3:30, 26 a.m.
Please continue to scroll.
Picture of a house at 10/30/2011, 3:30 and 29 a.m. Cactus and Landscaping, 3/30/2011 at 3:32 a.m. This is October 30th, 2011 at 3:33 a.m. This is October 30th, 2011 at 3:30 and 35 a.m. So
That's sufficient. Thank you. Unless you'd like to continue. There are more photographs from 3:30. I just.
Yeah. If you just go to the last one, it was access, you know, whatever time it was.
Continue to.
You don't have to go through it.
You're at 10:30, 2011, 3:30 and 36 a.m. You're at 10:30, 2011, 3:30 and 39 a.m. You're at 10:30, 2011, 3:30, 41 a.m.
That appears to be, or does that appear to be the end of the 3:30?
That is the end, yes. So the last one would be 2010, or correction, 10:30, 2011, 3:30 and 43 a.m.
So, okay. So, and just to be clear, it was user named David that was viewing?
Correct.
Okay. Did username David connect any storage devices to his computer during this time frame?
Yes. A Kingston Data Traveler USB device was connected at 10:30, 2011 at 3:22 and 08 a.m.
Okay, what function does a Kingston Data Traveler USB device?
You can store documents, pictures, PowerPoints, videos, audio, a variety of files. This one was associated with some pictures.
Did you determine whether or not the user account David was active on the computer later that day?
Yes.
Can you tell us the time it was active?
sometime around 7 o'clock into roughly 8-ish.
Let's change gears. And did you receive a Voyager LG VX or 10,000S cell phone to examine?
I did.
And who provided that to you?
It was received November 14, 2011 from lab technician Susan Clark.
Okay. Was it assigned an inventory number?
Correct. The inventory number for the Voyager is 2011-0626.
Okay. And did you perform an extraction or examination of this phone?
Correct, I did.
Okay. Now, first, I'd like to ask you, was the phone password protected?
It was not password protected, or I would have noted that in the report it did have a user code with the last 4 digits of the phone number being 4110.
Why would whether or not a phone is password protected something you would want to document?
Because the tools that we use would have to either brute force that password, or we would have to social engineer that password. A lot of times passwords are birthdays, anniversaries, things like that. But you risk the chance of changing data by guessing, so we have to use techniques to know that password or to sideload a dictionary in for that password.
Yeah, that was not necessary in this.
No, it was not.
Okay. What tool or program did you use to perform that extraction?
Celebrate.
Okay, and can you describe the process involved in performing that extraction?
So unlike a computer that we talked about earlier, where I had to remove the hard drive out of the computer in order to extract user data and system files and operating system, a cell phone has to be alive. It has to have a two-way communication with the tool in order to get that data. So the command is sent from the tool saying in simplistic terms, what context do you have on your phone? Then the phone will respond, I have this many contacts, here they are. With phones, before we ever turn them on, if they come into the lab powered off, we document that this phone was powered off upon our receipt. We immediately place that phone into a Faraday box, and all that does is block the radio frequencies from getting out. And then as soon as we turn it on inside that box, we immediately put it into airplane mode. And if a SIM card, in this case the SIM card was not present because of the technology that this phone carried, but we would have removed the SIM card as well. So in this particular instance, we placed the phone in airplane mode, brought it back out of the box, plugged it up with a cable associated with that type of connection for that particular phone, and then process it with Celebrate.
Okay. And how would you describe the Voyager that you were examining? Is it what was called a smartphone?
It was a feature phone with smartphone capabilities. So it did allow you to get on the internet, you could receive email and text message, but it did not have the app libraries or the Google Play Store or the Apple Store that we have now for apps and the like. So it was on the verge of wanting to be smart, it just wasn't, so it was classified as a feature phone.
It previously testified that a Voyager phone was given to Karen by her friends, the bonus. Did you find evidence of Karen Swift's use of that phone in your extraction?
I did.
Can you tell us what that was?
So in this particular phone, the phone number for the iPhone was stored as Karen S.
Clarify when you say the iPhone, which iPhone are you referring to?
So the very next item number that I received was an iPhone from Susan Clark as part of the... Then we get to the phone text messages.
The first sent text message does not have the prefix, but it does have 796-1910, and it's a outgoing message. Didn't mean to call from my other phone. If my husband calls from an 870 number, please don't talk to him. Say you must have the wrong number. Period. Karen, sorry.
Are there more texts that would lead us to believe, or might lead you to believe, that Karen was utilizing this phone?
The next one is an inbox receipt from that same number. Okay, but I want to talk to you. Then immediate response back to that number. Give me some time! Exclamation point. I filed a couple of weeks ago! Exclamation point. Karen. And then immediate response. Okay, please call if you can. I do want to see you. Then another one from that number. Call me, collect on a payphone. And then she responds back to that number. I can use this phone. It's an extra line of Kathy's, period. And then there's a star, Kathy B, star, FAW star.
Were there any text messages with this number on even before she went missing? Just hold on, if you will. There's a couple messages there we just passed. Go back up. Okay, and that lines 9 and 10 they appear to be identical. Who were those?
The first one is sent to a 676-3420. And it's, hey to YouTube, by Monday or Tuesday I'll have $500 cash towards the loan. Along with that, after I work this next Monday, October 24th, that will be 5 weeks. 200 period total, 750 exclamation point. I will have the remainder of 1250 in a couple of weeks, if not before, exclamation point. Y'all are the best, exclamation point. Thanks again, exclamation point. Give me my total monthly with taxes on this phone, and I will go ahead and pay for October. And then it's star, Kathy B, star, FAW, star.
Okay, can we scroll down to item number 13? Tell us.
Item number 13 is communication received from 731-796-1910. Good afternoon, beautiful. Then another response, outgoing.
Director Cheney, did there appear to be a response to the good afternoon, beautiful text?
Not immediately, no.
Okay, when is the next text associated with that
10/29/11, 8:25:29 p.m. Sorry, silent, got a lot going, exclamation point, Karen. Then an incoming response from the number ending in 1910 at 10/29/11, 8:26:47 p.m. Just call me sometime. I would like to get to know you. Then a response at 8:34:08 p.m. on the 29th, 2011 of October. Headed to the costume party now at the farms, Karen. Then a message received from the 1910 number at 8:35:44 p.m. on October 29, 2011. Okay, have fun. Call me sometime if you can. I would love to take you to dinner.
Okay, was there any more text messages, either ingoing or outgoing on this particular device?
The last one was the 11/14/2011 at 12:59 p.m.
Okay, and that obviously was well after. It appears to be some sort of business.
Correct.
Did you find any calls of adventure going on with the Voyager?
Yes.
Can you tell us what they are?
So any of on the incoming calls, there was no, the activities stops like at 3/26/2011, but the outgoing calls pick up roughly around 10/3/2011 at 6:21 p.m.
Okay. Direct your attention to the number 2 on that line. The 442-9451.
Correct. It's an outgoing call to that number. There's not a name in the contact list, or it would have populated there. And the date and time is 10/27/2011 at 1:52:05 p.m. for a duration of 4 minutes and 40 seconds.
Okay, were you, with your total involvement in this case, were you able to determine the owner of that number?
I believe it was. I believe it was listed as Jamie on another device.
I didn't understand you, sir. What'd you say?
It was listed as Jamie on another device. Jamie.
And that was at 10:27. Now, just to be clear, are these times that we're seeing here, are they in UTC or are they in local time?
They're in local time.
Okay, and would you describe what you see in line 1 there?
It is a call to voicemail, dialing the number of the phone, and that's 10/30/2011 at 9:57:37 a.m.
Okay, do phones like Voyager call voicemail on their own?
No, it's a manual process. You would have to hit either star 86 or dial into your voicemail box.
Okay. And did you examine the voice or the phone records, the Verizon phone records for this Voyager phone?
Yes, I did.
Okay, and were you able to determine whether or not the Verizon records show a call to voicemail at 9:55 on October 30th?
They did not.
How long after Karen's iPhone went off the network extender did the Voyager make this call to voicemail?
I believe it was roughly 5 hours and a few minutes later.
Okay. Do you have a professional opinion why the call to voicemail would show up in your extraction yet not be found in the Verizon records?
To my knowledge of the case, there was a network extender or for all intents and purposes, a cell tower in the home, right, to kind of simplify it. And that provided coverage in and around the immediate home. So if that phone was connected to that network extender, it would go through the data side of the house rather than the voice. So like we are used to now with Wi-Fi calling.
Now, direct your attention to line 3. Do you recognize the phone number associated on that line?
That is listed as 870-740-1577, and contact name is David S.
Okay. Were you able to determine if there were any connections other than this one between the Voyager phone and the defendant's BlackBerry?
I was.
Okay. Can you tell us about those?
On the BlackBerry, it was given an evidence item number of 2011-0638A with the number of 870-740-1577.
Were you able to examine this device?
Correct.
Okay. Did you also perform an extraction?
Correct.
Now, is the BlackBerry more or less advanced than the Voyager phone?
At this time, it would be considered a elementary smartphone, if you will. It did have its own app store, had other third-party apps that were included there that you could download and use, so it would be classified as a smartphone.
Oh, I'm sorry, I thought you were bringing up the contact, or do you?
I have
tell you what, we'll go over that when we get to the BlackBerry.
Okay.
The other phone Ms. Clark brought you on November 14, 2011 was an Apple iPhone 4, is that correct?
Correct.
Okay, did you assign an inventory number to it?
I did.
Okay.
The inventory item number for that one was 2011-0627.
Okay, were you able to perform an extraction on that phone?
No, I was not.
Okay, can you tell us why?
The phone, when it was received, the screen was cracked. You could tell the frame was a little bit bent. So when we tried to remove the printed circuit board, or the logic board in this case for Apple, to put it into a donor phone. So in essence, I would take the board out of that phone and place it into a iPhone that is operable, replacing the logic board so that we could power it on. Upon looking at the logic board underneath a microscope, there's capacitors around the processor chip, and the processor chip itself was cracked.
Okay, were you able to retrieve any useful information from your physical inspection of the phone?
The plate that covers the battery so that the battery stays intact has imprinted on it the serial number of that particular iPhone. From another piece of evidence that was received from the original proceeds of the search warrant at the residence, there was an iTunes backup that identified that same device.
So, make sure I'm clear. You obtained a serial number or ID number from the physical iPhone that you found.
Correct.
Okay, and that you were able to look at another, do you recall what device it was you were looking at?
It was a Dell Dimension desktop, I believe.
Okay, and what information were you able to clean off that computer?
So on 10/18 of 2011, and the time slips me right now without looking at the report, there was an iTunes backup, right? So the phone was physically plugged into that desktop. Apple iTunes was launched, and then a user created a backup of their device at that time.
And were you able to match that iTunes backup? Was there information on the iTunes backup that confirmed that it was done by the same device?
Correct. The info.plist gives that serial number that is tied to also the imprinted serial number on the battery cover plate.
Now, included in the items that were obtained from the search warrant was a list of BlackBerry phone. Did you perform an extraction on that device?
Yes, I did.
Okay. And did you assign it an inventory number?
I did.
Okay. Can you tell us what that is?
The BlackBerry phone is 2011-0638A.
Okay. And can you describe the process you used for that extraction?
So similar to what I did on the Voyager, the phone goes into the Faraday box. At that time, we remove the battery, check this, in this case, the BlackBerry is able to have removable storage. There was a 2 gig SD card that was there. We removed that. That's a separate, just like I would do with the computer. I would plug that up through a right rocker, image it, and then combine it with the cell phone. So powered on the BlackBerry, put it in airplane mode, brought it back out of the box, connected it with its USB cable to the software, and then performed the extraction.
Okay, were you able to identify a principal user of that phone?
Correct. It appeared to be Mr. Swift's work cell phone.
Okay. Did he appear to use it solely for business?
There were some communications back and forth with family and the like.
Okay. On the evening of October 29th through the whole day of October 30th, did you determine whether or not this device had any contact with Ms. Swift's iPhone 4 device?
There were a few call logs and a few text messages.
Okay, now I understand that you're, and correct me if I'm wrong, let me ask a formal question. How is the BlackBerry listed on your extraction? I'm seeing the screen right now.
Is it all chronological, or do you group things and incoming and outgoing?
It's grouped by incoming and outgoing in this method. There's not a chronological, or what we would look at now, the bubble look, right, when you can see the blue line and the green going back and forth to see the conversations. So it's at the time the tool allowed to pull that and then put it in the category that it was received in or sent.
Okay, so
Mr. Blunt, we need to take a short break. If I'm not interrupting at a horrible time. Sounds like we're on the front end of a different subject. So let's take about a 10-minute break. Ladies and gentlemen, please remember, don't discuss the case in the jury room. Don't form or express an opinion while we're in recess. Thank you.
All rise.
Constitution. Or coffee drinker. No,
right, let's be seated. I know you're messing with me. Yeah, and you all sat in the exact same seats this morning that you... All right. Mr. Box, you ready to continue?
I am, Your Honor.
All right, thank you.
Okay, we were, if I recall, Agent Wade, I had asked you about, could you identify, and we're limiting ourselves to the night of October 29th through the afternoon of the 30th when Ms. Swift was reported missing. Can we go through, and since your evidence is aligned and outgoing and then incoming, can you first, which is first on there?
Incoming text message. We can do the calls first if you would like.
Okay, yeah. How about outgoing calls to Karen from the BlackBerry?
So these are in UTC time. On 10/30/2011, if we subtract 5, we're at midnight, 41 minutes and 56 seconds. There's an outgoing call to Karen for 1 minute and 12 seconds.
Okay, when is that next one?
The next one would be at 1:41:42 a.m. On the 30th, 2011 of October for 47 seconds.
Okay, when does the next call begin?
The next call is 10/30/2011 at 10:28 a.m.
Yes, sir. And the next one?
It is at 11:19:53 a.m. for 35 seconds.
And then when is that next one?
The next one is at 1:31:24 p.m. on 10/30/2011.
Okay, were there any more outgoing calls to Karen before Mr. Swift visited the Marano on the side of the road at 3?
No.
Okay, were there any incoming calls from, during this time frame that we've looked at, were there any incoming calls from Karen's iPhone to the BlackBerry?
So at 10/30/2011 at 1:28:37 in the morning, call from Karen lasting 1 minute and 37 seconds. And then there's not another call incoming until call from Kathy Bona on 10/30/2011 at 2:05 p.m.
What about the text messages? Were there any text messages during the same time period between the BlackBerry and the iPhone?
Yes, there were.
Can we start with maybe outgoing from the BlackBerry to the iPhone?
So on 10/30/2011, this will be actually on the 29th when we subtract.
And that's line 82.
82, correct.
Okay.
Do you want door left unlocked, comma, how late will you be, question mark, garage doors are down, so use garage, walk indoor, period. Keely is in bed with me upstairs, period.
Okay, and we're just down, all the next ones appear to be from what's in the BlackBerry is Karen. Can you tell us the time and the content of the message?
Yes, so there again, it's 3 o'clock UTC. We subtract 5 from that, and we're getting still on the 29th. And it's have you checked on Ashley, question mark?
So that's at 10:52 p.m. on the
Correct.
29th?
Then the next one is at 10/30/2011 at 12:26:21 a.m. Are you okay? Question mark. Then the next one is not until 10:26:49 a.m. on the 30th, 2011. Where are you at? Are you bringing breakfast for the girls? Question mark. Then the next text message is 10/30/2011 at 12:01:58 p.m. Did you have to go back to clean that house more? Question mark, question mark. Then at 12:35:48 p.m. on 10/30/2011, where are you at, comma, are you with Kathy? Question mark.
Okay. Did the defendant make calls to, let's go back to the outgoing calls if we can. Okay, let's go to the morning of the 30th, October 30th. Did the defendant make any calls to the iPhone that morning?
No, there were not.
Can you go back and look up a little bit? Excuse me, you went down too far. Go back down. This 384, 85. Okay, so let's start on 382. When would that have been?
That is at 10:28:48 a.m. on 10/30/2011 for 20 seconds.
Okay, and then the next one?
10/30/2011 at do the math in my head, sorry. At 11:19:53 a.m. for 35 seconds. And then the next one is 10/30/2011 at 1:31:24 for a minute 59 seconds.
Okay, I want to focus on between 383 and 384. There's previously been testimony that the defendant called his neighbor, Jenny Lamb, at approximately 2 o'clock on October 30th, 2011. I do not see that on the extraction. Is there a reason why it may not appear on the extraction?
It could have been dialed from that device, but it might have been deleted, or it may not have gone through.
Okay. Just continue down. I'm interested in the calls he made. Excuse me. There it is right there on 387, excuse me. I was just curious. So, let's see, we have a couple calls to Preston, then to the neighbor Jennifer Lamb, and then to Kathy Bono.
Your Honor, I object to leading or testifying.
Would you tell us the calls he was making after he had called Karen for the last time at 1:30, last time that morning at 1 or early afternoon at 1:31?
He made 2 phone calls to a contact named Preston, 10/30/2011 at 1:45:39 p.m. for 12 seconds, and then again to Preston at 10/30/2011 at 1:46:05 for 2 minutes and 16 seconds. Then a call to a contact named Jennifer Lamb 10/30/2011 at 2:09 and 23 p.m. for 3 minutes and 11 seconds. And then a call to a contact, Kathy Bona, 10/30/2011 at 2:25:47 p.m. for 4 minutes and 40 seconds. And then shortly thereafter, another phone call to Kathy Bona, 10/30/2011 at 2:34:36 p.m. for 4 seconds. Then another phone call within the same minute, but separated by a few seconds, 10/30/2011 at 2:34:50 p.m. for 3 seconds to Kathy Bona contact. And then on 10/30/2011 at 2:35:23 p.m. called the Kathy Bona contact for 2 minutes and 51 seconds.
Okay, keep going, please.
Then called Chris, and I'll mispronounce this last name, but Nafi Sell, 10/30/2011 at 2:38:24 p.m. for 1 minute and 49 seconds. Then a call back to Kathy Bona, contact at 10/30/2011 at 2:40:21 p.m. For 0 seconds. Then to Kathy Bona again on 10/30/2011 at 2:40:36 p.m. for 1 minute. Then Kathy Bona again at 10/30/2011 at 2:41:41 p.m. for 0 seconds. Then used *67 to mask the number and dialed what is listed as Dyer County Sheriff at 10/30/2011 at 2:41:55 for 0 seconds. Then dial what is listed as Sheriff's cell phone at 10/30/2011 at 2:42:12 p.m. for 15 seconds. Dial the Sheriff's cell phone number again on 10/30/2011 at 2:43 p.m. for 24 seconds. Then call the Jennifer Lamb contact again on 10/30/2011 at 2:52:54 p.m. for 6 minutes and 19 seconds. Then called a cell phone number with not a contact listed of 731-285-2208, 10/30/2011 at 2:59:31 p.m. for 6 seconds. Then called the Dyer County Sheriff contact at 10/30/2011 at 3 p.m.
And how long was that phone conversation?
4 minutes and 7 seconds.
Okay. Changing topics for a moment. Did the BlackBerry have any contact with the phone number 731-442-9451?
Nine, 2, 5, 1, is that what you said?
442-9451.
Yes, it's listed as Jamie with a Y.
Okay, and are we on outgoing still?
Let me check.
Or incoming?
Let me check real quick. It's incoming first.
Yeah.
So there was an incoming call to this number on 10/30/2011 at 5:30 and 3 seconds p.m. for 16 minutes and 10 seconds.
Okay, now can you go to outgoing and determine on that October 30th whether or not the BlackBerry made any calls to the Jamie contact? If you were there, that's incoming there.
It might have been the end of incoming. I just want to verify.
was outgoing, sorry. So that was an outgoing call to the Jamie contact with the Y at 10:30/2011 at 5:28:27 p.m. for 1 minute and 8 seconds.
Okay, are there any more than on that 30th?
Then another phone call on 10:30/2011 at 4:12:56 p.m. for 33 seconds.
Okay, and this phone number that David's phone has listed as Jamie, is that the same phone, the Voyager phone, called on 10/27?
I believe so.
Do the Verizon records, to your knowledge, show any calls between the 442-9451 Jamie number and Karen's iPhone?
I don't believe so.
Agent Wade, would you make your reports on the examinations and extractions you performed and exhibit to your testimony?
Yes.
So we caught that on a thumb drive?
Correct, it is.
And that encompasses everything that you have done in this case?
Every work product in this case, yes.
I'd be admitted as Exhibit 34.
Agent, let me ask you just a few questions. You received a laptop that the Gateway computer laptop that you were testifying about as a result of the search of David Swift's house.
Correct.
That occurred November the 14th of 2011.
I received it November 14, 2011.
Thank you for correcting me. You examined it.
Yes, sir.
You weren't there when they did the search, were you?
No, I was not part of the Violent Crime Task Force.
You don't know exactly where in the house the laptop was located, do you?
I can read the evidence logs and tell you, but I was not present there, no, sir.
Okay. And you testified also, when I'm thinking about it, about some other cell phones and electronics that you examined in this case.
Correct.
You mentioned a cell phone with swollen batteries.
Yes.
Some of these could have possibly been old phones that were on the scene.
Yes.
So the one that was swollen, you testified about swollen batteries, you couldn't extract any information.
Not at that time, no, sir.
It's fairly common for people to keep old electronics sometimes.
Absolutely.
And you just examine whatever they brought you.
Yes, sir.
Now, the Gateway laptop, you indicated that there was a logon for David Swift.
Correct.
Now,
Well, it was the logon for David. There was not a last name associated with it.
okay, was there a logon for others?
There was not any other local account, no.
Okay. If that was a laptop that was being used by several people in the house, is it possible that they had others, if they used it, had David Swift's logon password or logon?
It's possible.
Now, when you say logon, is that, this is 2011, is this just like a short code?
It could be digits, it could be a passphrase.
And if I, for example, if I share my logon with others in the house, then they could just click on it, put that in, and then have access to anything under my username.
Correct.
And you don't know whether or not that was done or not done in this case, do you?
No, I do not.
So if there had been another person in the house or children that came from time to time, it's possible they shared this logon information when they were at the house, used the computer.
It's possible.
You're processing the information you received to see what it shows.
Correct.
Now, the report that you did fairly recently is Is it the Axiom?
Axiom is a product of Magnet, yes.
Was that done pretty fairly recently?
Within this year, yes, sir.
Not in 2011. I guess that program wasn't there then.
It was so the program in 2011 was Internet Evidence Finder, made by the same company. Internet Evidence Finder was a precursor to what now is Axiom, which is what they have branded their forensic suite.
And you use that as far as the laptop to tell about the dates of the activity?
Correct.
And is there a conversion that's involved to figure out, you indicated a 5 or 6 hour window. Is there a conversion ratio?
So all dates are stored in UTC, and so at this time frame in 2011, we were in this area where this laptop and device was located was -5.
Now -5, what does that mean?
So we take at the prime meridian, right, in Greenwich and all that, that's absolutely 0 time. So then we subtract back 5 hours and we get to Central Time in this part of Tennessee.
In October the 30th of 2011, what are you saying the time was?
It would have been 5 hours behind what absolute time was.
And would that have changed, like, this is the end of October, and you've heard of daylight savings time?
It would have changed later on in November.
Do you know the date it changed?
I would have to look it up. I don't recall.
And how would that affect it? Would it
It
fall back?
it would move it back 1 more hour.
So it would be the fall we fall back.
Correct.
All right. And on October the 30th of 2011, you believe the time was not, you believe it was on daylight savings time?
Correct.
Now, if I could. If I could pass this to the witness. Sir, I'm going to hand you a calendar from November of 2011. Would you look on the date of November the 6th?
That's when daylight savings is marked, yes.
Now what?
The tool takes into account that date, so it's going to be -6, but if it's prior to that, it would show up as -5.
So, but were you computing it as -6 or -5?
When I was reading the UTC times and one of the evidences, I was computing it as -5. When I did that extraction, it was already set to daylight savings because it's a checkbox that we can check to have daylight savings enacted, so it knows where the calendar is without reading the calendar.
But daylight savings time would make it an hour earlier would be November the 6th of 2011.
Correct. That's when, in this year, based on what you're showing me, would have been November 6th. What I'm telling you is the tool takes into account daylight savings regardless of when that is. So it calculates that timestamp. If it's showing -6, that's the standard for Central Time for this region of Tennessee. So it's going to either be -6 or -5. If I misspoke based on saying -6 or -5, the time still would have been the time.
Did you personally check it yourself, or did you rely upon this tool?
No, I validated.
And if on November the 6th of 2011, when daylight saving times changed, that would have made it a 5-hour window, a 5-hour conversion,
No.
or would it?
It would have been 6 hours on November 6th. Prior to that, it would have been -5.
Okay. And you did review that in daylight savings time. You're satisfied on this calendar as November the 6th of 2011?
Based on what you're showing me, yes.
Judge, I would just ask judicial notice be taken of that date on the calendar. I showed it to the prosecutor. I can pass it up to the court.
Do you disagree about that, Mr.
No objection. We've looked into it, and that is in fact in the daylight savings change.
I guess that be made an exhibit.
Michael, Exhibit 35.
I'm sorry. A couple of other things. You were showing, you testified, the prosecutor asked you a number of questions about the computer and the times, and you indicated, I guess through this relevant period, that you showed activity on October the 30th at 3:13 a.m. through 3:30, 41 seconds. Would that be correct?
I believe that's roughly the time range of the pictures we showed you.
And so, to be honest, you can show somebody used that laptop to have some activity with the pictures.
Correct. Somebody had to physically plug in a thumb drive to view those pictures.
Now, it had to be somebody that used the, I guess, the login or logged into that laptop.
Correct. There's a, and we didn't go over it, but at 2 o'clock, well, like 2:46, there is a log on of that account on that day.
And so, if people were at the house, whoever logged onto it could have downloaded these pictures. Sure. You can just say it's somebody that logged on, whether it be Mrs. Swift or David.
I can't say who. I can just say that user account was used to access those images.
Now, the images were largely family pictures that you indicated were being downloaded to the computer?
Viewed, not necessarily downloaded.
And there's nothing about that you can tell which individual other than the person that logged onto that laptop viewed those images, can you?
I don't know who viewed them. All I know is that account was accessed to use to view those images.
And a lot of them are family pictures and things of that nature.
Correct.
But you could say that at that time, whoever logged in during that period from 3:13 to 3:30:41, you don't know where the laptop was either in David Swift's bedroom or either downstairs in the living room, do you?
I have no knowledge of that, no, sir.
And it could be that someone woke up and looked at images or had this activity.
Somebody was on that device at that time. I don't know if they woke up or they were already up.
Or somebody arrived from a party and was interested in accessing images.
That's possible.
Were any photos downloaded?
There might have been some photos downloaded. We would have to go back and look directly for that.
And if a photo was going to be downloaded, would that be from a certain device, like a phone or a camera?
Or the internet, yes. Could have been from either, all three of those.
Can you tell who was downloading, what device was downloading or not?
I can tell in the metadata what device created the original image. I can't, outside of that, there's not any way to tell who was connecting it or...
Whether it was Mrs. Swift or,
correct.
Or Mr. Swift.
Or anybody else.
Yes. Now, if I take a picture and I send it to one of my family members, they'll have that image. And when they download it, if they choose to download it like in this manner, will it show that it originated from my phone?
Well, that depends. It will have certain metadata artifacts that will attribute to the aperture, the frame rate, all that of that particular picture. And it may show that it came from your phone number, right? But when it gets put on another piece of medium, it gets created a new accessed and modified date. It'll have the modified date as the created date of the original image.
Okay. So if I send a family member photo I've taken and they choose to download it, would it look like it was originated from them?
Potentially, it could look like it was originated from them, depending on what is left in the metadata.
Okay. I wanted to make sure I understood that. Now, I guess the time frame you're talking about on the laptop from 3/13 through 3/30/41, it does indicate that whoever accessed it was home, was with the laptop wherever the laptop was.
Was with the laptop wherever it was. Yes, I don't know if they were home or in the backyard or where.
Right. But it would indicate that they're with wherever the laptop is. If the laptop's in the home, then they're in the home looking at the laptop.
Correct.
Either in a bedroom or in a common area.
Correct.
Okay. The 1577 is David Swift's phone number, iPhone.
I don't have an iPhone in this case.
I mean, his BlackBerry, I misspoke.
I believe the last four are correct, yes.
Okay. And the prosecutor asked you about my client's, Mr. David Swift's, his phone contacting or trying to contact the iPhone of Karen Swift.
Correct.
The records you testified indicated that he did try to communicate with her on October the 29th.
Correct, yeah, it was our early hours, yes, almost into the 30th. Correct.
And she responded?
I don't believe calls, I'd have to go back and look, but I believe there was communication through text and calls, if that was what it shows.
And indicated that there was an issue with his daughter?
I don't know if there was an issue, just asked if he had checked on a particular daughter.
Okay, that's fair. And then at some point, that stops. And then the next morning, the prosecutor asked you, and you indicated that there were calls from David Swift's cell phone in trying to contact his wife or ask her questions.
I don't believe there were calls, I believe there were text messages of him trying to reach out.
There's contact.
Correct.
And there's several attempts at it.
Yes.
And there's no response.
Correct.
Okay. The prosecutor asked you some questions about Mrs. Swift's phone calls, I guess, to somebody else on the night of the evening of 10/29/11.
Yes.
Was that from the Voyager or from her iPhone?
I don't have an extraction from the iPhone. It was from the Voyager.
Yeah. All right. And you read those out, and those are accurate emails indicating some contact or wanting to see somebody else.
There were no emails. It was just contact or text messages, yes.
It was text messages.
Correct.
And it was a conversation between two phones about contact.
Correct.
What you read out earlier is exact word for word.
Yes.
And one of them was about seeing or getting together.
Correct.
Along those lines. On 10/30, well, let me make sure. On David Swift's BlackBerry, I guess the calls to his wife's phone, iPhone, start mid-morning, generally.
I believe that's correct.
And they continue through that afternoon.
There are a couple, I believe, yes.
You read them out earlier, correct?
Correct.
He also has conversations, either receives calls from others that afternoon of 10:30.
Correct.
Or
made calls.
Yeah. And they indicate trying to locate his wife.
I don't know what they indicated. I don't know what the conversation was. I just know that they were.
Yeah, I'm sorry. They weren't text messages, they were phone calls.
Well, that's what you asked me. They were phone calls.
Yeah. You can just tell who he called.
Correct.
You can't, there's no text messages to others?
There are some text messages, but I don't know in reference to who they are in reference to him.
Okay. And if these witnesses have testified previously that they either had contact with David Swift or called him, that might explain some of them?
It could. I don't have any knowledge of that.
Okay. Just 1 second, I'm almost finished. Now, in order to download photos from an iPhone, would you need a password, or
Not necessarily.
would you need a user ID?
For the computer, in this case, you would not necessarily need one because it was not on the gateway, it was on a Dell Dimension.
Right, but if I'm downloading something from my phone, do I have to plug it into the computer?
You've got to plug it in, but there may or may not be that ability or that requirement to unlock the device or to have a login password.
But if the iPhone was used to download, and I guess every so often, do you have to, like if you don't use your phone, do you have to do something to gain access to it?
Yeah, you have to put in the password if it's set, but I didn't examine the iPhone content because it was destroyed, so I have no idea whether it had a password.
Whether it did or did not.
Correct.
And if there's been testimony that Karen Swift changed her password and username all the time, it's possible there could have been a username or password.
It's possible. I don't have any knowledge of that, though.
And you're saying the Voyager phone was not password protected?
It was not password protected. It did have a user code, which is for the operating system, is pretty default, the last four of the phone number.
Just 1 second. I made several notes, but so on the iPhone, really, you mentioned about the state of it, Karen Swift's phone, that you just have the backup of the iPhone. Is it possible that that is all you have to indicate whether or not she did or did not save pictures or download pictures?
That's the only time that on that device, that desktop, right, that Dell mentioned, that she backed up. If there was previous backups or backups after 1018, they would have been there. Or they could have been deleted, right? So that option is there as well. But there's no indication that there was any other iTunes backups of that particular iPhone outside of 1018 on the Dell Dimension. Every other computer that I examined did not have any other iPhone iTunes backups.
I guess if you just have the backed up version, that's not, and the person doesn't back up their phone, they go 2 or 3 weeks and there's activity like taking photos or deleting photos or downloading photos. Unless you can access it, you wouldn't, and had the correct device, you wouldn't be able to tell whether they downloaded it or backed it up or not.
Well, you can back up your phone in a variety of ways. You can either back it up to the computer in this instance, or you could have backed it up to the cloud. I don't have any knowledge of that. There again, I've never backed up a phone, so when it fills up, it just fills up. But people back up their phones quite frequently, and there's no rhyme or reason as to why they back them up. They may back them up so that they can get a new phone. They may back them up because there's an update coming out and they don't want to lose the content that was there in case the update messes up. So there could be a variety of reasons why that backup was on that computer. I can't answer you why there's not any more backups. All I know is when I got the iPhone, it was not in a condition to be analyzed forensically.
And if things have been saved to a cloud, you didn't have access to that?
I did not, no, sir.
Thank you, sir.
Direct your attention to the activity on the gateway, not the 7:30 to 8:30 activity, but when you said that the gateway was, user David logged on at around 2:45 in the morning?
I believe so.
And stayed on until about 3:30 when we saw this scrolling picture?
Correct.
Okay, does that mean that, when you said that that user was logged on during that time, does that mean they were actively at the computer pushing keys?
Those files were actively accessed during that time frame, so they had to have, whoever was behind the computer had to have some involvement to view those files.
Okay, but I mean, if I logged in at 2:45 as user 10, and then I had to go to the bathroom, and then I come back, am I still logged on?
You're still logged on.
Oh,
Just one more question.
If you log on, you're saying that they're showing that the person did some activity. They just didn't plug their phone in. They did some activity like scrolled through or looked at photos.
There was a external device. I can't tell you whether or not it was the phone at one point or another. We do see in the proceeds with the USB evidence that was presented that a Kingston data traveler USB device was plugged in. Because of the way that digital camera folder structures name their folders, I'm not able to determine whether or not that digital camera was a phone or a USB device that had copied those files from the digital camera.
Right, but I'm saying the ones that you went through, all the pictures at the times, you're saying that that wasn't an automatic thing. There had to be somebody scrolling.
Correct. They are, as the pictures load and they're scrolling down, that's why we see the variation in timestamps, because it's taking that thumbnail snapshot of the original image and displaying it in the file view.
So there was activity that indicates that the person was using that device.
Correct.
The person wasn't gone or just simply plugging it up and gone elsewhere.
No, they were actively on the device at that time.
One more thing, and I'll sit down. Did you examine a camera?
I examined several cameras.
You can't say which device the download of the photos came from, or?
This one appears to be a Kodak Easy Share, but there was not the same SD card was not found with the camera at the time of the examination.
Thank you.
Sir, you can step down. Thank you. It was Thursday. Call your next witness, please.
United States risk.
Ladies and gentlemen, we have some things we have to take care of without you being here, so we're going to go ahead and take our lunch break just slightly early. I assume lunch will be 10 minutes. 10 minutes, mark it down. Now, while you're at lunch, do not discuss the case among yourselves. Do not form or express any opinion. We have not presented the proof in the matter yet. Okay, we'll see you back after probably about.
All rise.
The state is arrested. That concludes the state's proof. I would argue and submit and move for a motion for judgment of acquittal on the charge of first-degree murder or possibly any lesser. I would say this in support of that motion. Karen Swift they had marital issues. We've heard about those a lot. There's proof that my client went over to where she was. There's proof that he checked on her. There's proof that he asked her questions. There's evidence that she was eventually was doing other activities. We talked about in marital situations where sometimes they grow apart. That's the case here. These continued. There were activities. My client called. My client went over sometimes. My client checked on them. There's no evidence that we've heard of any violence in the proof. And at some point, Karen Swift files for divorce. She leaves. She takes the two girls, and she informs my client that she's filed for divorce. They've been divorced before. They've reconciled before. And my client goes to the lawyer's office and picks up the papers, and he goes back home, he goes to work. She returns from the trip. He returns to their home. They live together in the same house. They continue their activities. He works, and she does some of her jobs, but they continue to live in the same house. There's proof that my client did injure his leg, re-injure his leg before she went missing on October the 30th. I submitted almost a week before. There's activities going on. David Swift's at home with his daughter. Mrs. Swift arrives after midnight on October the 30th of 2011 with the daughter. The state played the tapes of my client. He was interviewed. He agreed to be interviewed. He was interviewed twice on those two tapes. He answered their questions. He said that I didn't do anything to her, in essence. I'm not sure where she is. This is the history that we've had before. They ask him all the questions they want to that first time. And the second time he comes in, they ask him all the questions that they want to. And he tries his best to answer them. And he leaves. He comes into the interview, and you hear all of that. David Swift goes home. He continues his activities with his family. The testimony, the proof indicates that my client on Sunday morning, after he got up, and it is consistent with the morning, around 10:30 or 11, I'm just going off memory, Judge, starts trying to figure out, hey, did she go to Trimble to finish cleaning the house, or she with Kathy Bona, and, reaches out for her. Indicates he doesn't have any knowledge of where she is. The state doesn't agree with that or believe that, but that's what the proof, and in fact, Kathy Bona testifies about it. Proof indicates my client was informed by a neighbor, Miss Lamb, I believe, that the car was out there, and he took his daughter and went up to the car, and then he took his daughter to the mall, or wherever Miss Lamb was away from there. and then comes back, and the bonus are there in law enforcement. My client cooperates. Law enforcement asks him questions. He takes them willingly, takes them in his house. The state's alleged that there was a brutal murder that occurred in their argument in the house, and that he tore her clothes off and stomped her to death in the garage. However, when he goes from the car, law enforcement says, "Can I come with you and look in the house?" And Mr. David Swift agrees to that. And they walk in through the garage. The officer does testify that he didn't notice anything out of the ordinary or smell anything. They infer several things or suggest several things about bleach and stuff later. The officers, several officers, a couple of officers come out to the house and walk through, but there's no, and David Swift takes them through the house. He lets them go wherever they want to. He cooperates. The officers eventually come back, they come again the next day, several of them, and do things. This is the Dyer County Sheriff's Department. At some point, and there's really nothing out of the ordinary. Outside there's a burn pit, which can indicate garbage is burned, but there's no clothes burned or anything of that nature. And they come back with a search warrant. He has to vacate the house, and I submitted the TPI, went out, and did a very thorough inspection and search of the house, looking for forensic evidence. They take swabs in the garage. They take swabs from anything that they see maybe a stain or possible blood. We've heard the results of that. There is no human blood in the house. The state suggests that there's bleach. It's been cleaned or whatever. There's a pool back there. You can see it in the picture. And bleach can also be used for non-homicide reasons. But it's on the property. It's in the trash. They pull it out, but they do a thorough inspection. There is no forensic evidence indicating that she was killed or murdered in the house, I submit, or the garage. They suggest that her body was loaded in her car and transported away sometime that night. The car was thoroughly examined. There is no indication of a body being transported in the car. You heard the questions that we asked. The trunk, blood, hair, prints. Prints were taken. I don't know if they've been introduced, the results of it, but the chief investigating officer for Dyer County, who already testified, indicated there was nothing of any, no results that were conclusive showing that anything occurred in the car. The state is suggesting that my client did this, and then I guess they're trying to say dump the body at the cemetery or at the Mississippi River, wherever this ping, near the Mississippi, on further out where the ping was. You saw the videos about that. We have computer activity that I guess the state suggested my clients at home operating on the computer. Karen Swift, I think the proof shows, came home around 1:30 or 2 a.m. on the 30th, whichever Your Honor remembers. I've heard different things. And that she's at home. She didn't plan on coming back to the house. We've heard that through the bonus. And that she had the intention and told people she was going to clean the house in Trimble. So it's not inconsistent that she would get up and leave early in the morning to do things, whether it be clean or go to the gym. The state's forensic expert on the computer just testified that they believe, if you believe David Swift was on the computer, he was at obviously wherever the laptop was. So I don't know if laptops work while it's driving down the road. I don't believe so. I believe if it was at the house or in his bedroom, if he woke up in the middle of the night and looked and then went back to sleep, I don't know, but the laptop's at the house until a period around 3, if if I recall 332. I may be off. And then after that, these things happened. We submit that the evidence is insufficient. We submit that the evidence is insufficient to show premeditation to support first or second degree murder. We submit that the evidence is insufficient to support a conviction in this case. We've heard a lot about them and their activities, hers and his, about following and going to. We've heard about some of the things she was doing and that the marriage was having problems. That doesn't mean that a person killed or murdered somebody. They divorced and reconciled before. And so, is it possible this time that could happen? I mean, you could argue, and the state also argued that he didn't have a lawyer, when in fact their own witness indicated that he did have a lawyer. Lawyers take money, and so people don't waste money. And if you believe what the state says, he killed her because he didn't want to go through the divorce and lose his money. He was spending money on an attorney to represent him, I guess because he recognized that she might be willing to go through this. Maybe he was hopeful that she wouldn't, but that doesn't indicate he committed this crime. And so for all these reasons, we submit that the evidence is insufficient to support these charges.
Go ahead, Jim.
Your Honor, the state has provided more than enough proof for this matter to go to the jury. This is a jury question. First of all, Your Honor, as you know, the divorce was filed on October 10th, and there's been proof that the defendant had motive because of the divorce, because of the control that he always wanted to have over her, the fact that there was testimony that he wanted a perfect family, and she was going to break up that perfect family that he always wanted. Your Honor, there were numerous inconsistent statements from the defendant. There was testimony about whether he saw her or not. He told at least 4 different stories about when she came home that night. The first story was that he talked to her, but he never saw her. The second story was that he talked to her and he saw her, but he didn't know what she was wearing. The third story was he talked to her and she was wearing a gray sweater with blue jeans with holes in it. The fourth story was that he saw her, and then later that night he saw her as she was leaving the house and asked where she was going. We've got 4 different statements from a person that occurred within a matter of minutes. And we've proven that. He talked about it in the videos. We've put on more than enough evidence that that's inconsistent. And he also had inconsistent statements about whether he knew there was a second phone. He told the officers in his interviews 2 different times in 2 different interviews that he had just discovered that day or the day that she came missing that she had a second phone. And we've put on proof that that is not accurate. There are actually phone records where he had called that phone prior to that. There were witnesses who testified that he told them that she had a second phone prior to her becoming missing. And, Your Honor, we've even presented proof today that that phone was accessed and called by his number. Your Honor, the defendant also gave inconsistent statements about what he was doing that night. He told officers on more than one occasion that Karen Swift came home at 2:08 in the morning, which we know by the network extender and when her phone connected. He told officers that when she went to sleep, that when she came home, he went back to bed and went to sleep, and he stayed asleep until 10 or 10:30 the next morning when his children woke him up. You know, we put on proof that that's not consistent as well, because it was his computer with his name, with his password that logged in. He was on the computer in early morning hours at the time that he claimed that he was sleeping. In addition to that, he had a device that was connected to the computer that was downloading photos that we suggest was possibly Miss Swift's phone. And we'll make arguments about that at a later time. Your Honor, in addition to that, The proof was that the defendant stated himself Keely was in bed with him, which indicates she was upstairs. The defendant himself said that Ashley went to bed with Karen downstairs. When they woke up, they were in bed together. So someone took Keely from upstairs and moved her downstairs. Now, why Miss Swift would have a reason to go into the bedroom of a person that she does not even want to be around, and if she's going to sneak out, possibly wake him up just to get the daughter and move her downstairs, it's not logical. The other daughter was also moved from the bed with Karen to the bed with the other child. They both woke up in the same bed. Your Honor, in addition to that, if Miss Swift was going to be on the computer, or if Miss Swift was planning to leave just a few hours after getting home, why would she take diphenhydramine to help her sleep? In addition to the fact that you heard testimony that the alcohol that she had already drank would make that even worse, make the diphenhydramine work even stronger than usual, to make her even sleepier than usual. It makes no sense that she would take a sleeping aid and then an hour later or hour and a half later be up on the computer. And also within 2 hours that she would get up and leave. If she was going to be on the computer also, she wouldn't get her husband's computer, who testimony showed he changed the password a few days after the divorce, which indicates he didn't want Miss Swift to be able to get into the computer. Also, if you on the photos that were shown, there was a computer in her room, a desktop. If she wanted to use a computer, there was already one right there in the room. Your Honor, there was testimony about the screw being placed in the tire. You heard that testimony that that was intentionally done. It was manually inserted into the tire. You also heard proof about that screw, that when it went into the tire, it sealed the tire. So the purpose of putting the screw in was so that it would go flat. But the testimony was it sealed the tire, so the tire had to be manually deflated. You know, the proof was that Miss Swift's cell phone left the house at 4:38 a.m. And we know that because the cell phone disconnected from the network extender. We had proof from Mary McWaters that at 4:40 a.m., 2 minutes later, she hears a car coming down the road with a flat tire. And that noise stops when it gets to the intersection of Harness and Millsfield, where Miss Swift's car was found. You also heard proof from the expert on the tires that there was run flat damage on that tire. He indicated that run flat damage would have been done in less than a mile. Miss Swift's house was a quarter of a mile from where the car was found. Your Honor, in addition to that, he talked about the screw and that there would have been more wear on the screw had the tire been driven for a long period of time. At 5:04, the phone pings, and you heard from Carla Rexing with the FBI that there was an arc of where the phone could have been. And the ping, one of the pings that the Sheriff's Department thought was that it was by the Mississippi River. She showed that on that arc that it was more likely it was in what she called the area of interest, which was the house and where the car was found. But we also put on proof that where that ping was, if it was by the river, was a round trip drive of 41 minutes. You know, and it does not fit within the timeline that we have for a person to be able to drive there and back with a phone. Because we know that because she also said that the phone was moving. At 5:04, the phone started moving. But she said it was moving at a pace of a person who was walking with the phone. She said if the person was driving, it would hit more towers and different towers. And because it stayed on that same tower, it indicated a person was walking with the phone. At 5:09, the phone stops working. And we submitted that as the time that the phone was destroyed. The phone was stomped at that time and it stopped receiving data. In addition, when Officer Alexander arrived on the scene, he testified that the car was locked. The bonus testified that they were the first ones to get there, and the car was locked. Officer Alexander had to get Mr. Swift to go home, get the spare key, and come back to unlock the door. He testified that when he got in that vehicle, the seat was in the position that was all the way back. Miss Swift was a small person, and it would be impossible for her to drive that car with that seat all the way back. The seat would have to be in a forward position for her to reach the pedals. The defendant claimed that he had a knee injury, and that's a big part of this case, because he claims that that happened on October 25th, which was right before the incident where Miss Swift became missing and was murdered. You know, that's very important because that shows his premeditation. He started planning this several days before. So he had to claim he had a knee injury so that he would not be physically able to commit a murder. We put on ample proof, Your Honor, that that was not true. We put on proof of individuals who saw him the day before this happened, who was walking without crutches. He was climbing on and off of a four-wheeler without any use of crutches and without any problems with his knee. And the day of the Halloween party, Mr. Swift actually takes that hay back, climbs up in a trailer, gets 65-pound hay bales, and either drags or hands those to Mr. Harris to help load those. A person with an injury to his knee so severe that he had to have crutches would be impossible to climb on a trailer and move the hay bales in that manner. In addition to that, you heard from Kerry Smith, who was a physical therapist. And he told you that the defendant did have the strength and the range of motion that was needed to drag a body 20 feet from where the car would have stopped and where the body was found. Your Honor, also, the defendant admitted that he did clean the garage with bleach. He told the officers that he did that because there was vomit from a dog in the garage. So he used bleach to clean that up. Your Honor, the state submits that that was also a part of what happened that night. If you'll recall, the TDI agents had testified when they went and did the search of the garage that they received presumptive positive tests of blood in that garage. And they stated that when they took it back to the lab and did further testing, it did not show the presence of human blood. However, he testified more than once that something caused that to be positive. He also stated, when asked, that bleach could cause that to happen. That bleach is one of the best tools for cleaning up blood, and that it could have caused the blood to not be in the same condition that it typically would be when it was tested at the lab. You heard from the medical examiner. He talked about the injury. He talked about the possibility that he didn't know what could have happened as far as whether she may have been strangled. He could not say that she was or she was not because the hyoid bone was missing, as well as the thyroid cartilage. He did say that the fatal injury, regardless of whether she was strangled, was the wound to the head. That it definitely by itself could have been the fatal injury. He said that this was the type of injury that could have caused little or no blood. He said it could have been a closed head wound injury. He also said that if the person was strangled and the injury to the head happened afterwards, that there would be little to no blood because the heart was no longer pumping. Your Honor, so there are more than one explanations of why there may not have been a large amount of blood in that garage. Your Honor, the state believes that based on all this, we have given more than enough proof for this to be a decision for the jury to make, and we would ask that you deny the motion.
Mr. Goodman, does the state acknowledge that the state's case primarily, if not totally, is circumstantial?
Yes, sir, it is.
Okay, thank you. Anything else you want to add, Mr. Taylor, to your motion?
As you're asking, just a few more things. Regarding the issue of the blood in the garage, of course, I listen to and ask questions of the witnesses. Sometimes we hear things differently. Blood is used to clean up at the lab. I recall the witness testifying.
Bleach?
Excuse me. Bleach is used to clean up blood. They don't go together. And it could affect the results of the test. So bleach either eliminates blood or it would test positive for blood, but fail to show any other results, I believe is what I understood. In this case, the swabbing of both walls and the floor of the garage indicate the presence is blood not of human origin. That means it's not a human. They can't tell if it's a dog or a cat, but it's not a human. They do have a result. It's not human. So if it's not human blood, if he's cleaned up the garage, it makes sense based on what the witness said that they could show the presence of blood, but this is so degraded, the sample, that they can't tell anything else. They can in this case. It's not human. That means I infer it's animal blood. They can't say what type of animal. We belabored the smell of bleach and all that, which is, nobody indicate that in the car, the garage. To say that my client, I guess the state's arguing that they're basing this plan of premeditation on my client allegedly faking an injury of himself and then staging it to make it look like he's injured so he knows he's going to kill her. We do, just from what we have right now, if you just heard the state's proof, you hadn't heard anything else, we do have Dr. Smith, not Dr. Smith, but Kerry Smith, I think this is his name. He was pretty animated, but he indicated that he doesn't believe that my client, he did have an injury. He did also get the referral from a doctor that my client saw before he saw Mr. Smith. And it indicated he had an injury that was serious enough that it affected his ability to get around. And so we got a doctor referring him to a physical therapist. The physical therapist asked him what he thinks in his own mind he can do or not do. And the therapist puts him on a treadmill, and he's holding on to the sides, and he's trying to walk to show him. He indicated my client was trying to push himself to show that he was trying to get through it because he had work responsibilities and family responsibilities. There are numerous witnesses that saw my client with the crutches, and also that saw him with a leg immobilizer. You can see it on the tape when he goes and talks to the police. And I guess the state suggested my client staged the whole thing so he could commit a murder. And even though Karen Swift intended on being at the Bona's house that night and not coming back, and we're not clear because Karen would sometimes go and not let him know where she's going, or sometimes she would. She comes back unexpectedly, and he's planning all this with a leg injury so he could just get his hands around her and kill her on that occasion. It didn't make any sense. As far as inconsistent statements, the journalist, this is a case from 2011. They've relied upon questions of witnesses for the state and of my client interviews. Hey, the newscaster called him while he was at lunch and asked him a few questions. The newscaster couldn't remember. Well, I think he said, but I'm not really sure. You go off what you remember, Your Honor, that the newscaster that was writing a book and others. I don't know. It's just sometimes people, as a lot of the state's witnesses when they came in here, they testified for the state. And you recall how I had to drag things out of them by use of a transcript that were different or explain fully the circumstances. People over time get things mixed up. Does that mean they committed first-degree murder? It does not. The proof is insufficient. And I submit it to Your Honor.
One other thing, please. Your Honor, as far as premeditation, we did talk about the injury to the knee as part of the reason for premeditation. Another thing is, if you will recall, more than one witness testified that Mr. Swift attempted to go to dinner that night with Ms. Swift. He wanted to talk about the divorce. She refused. She told him it was over, that there was nothing else that could be done, and she was going to the party rather than doing that. You also heard testimony from Janie Helm that he was furious about that. You know, also also it could be that that was the moment that he put this plan into motion.
State acknowledges that its case against the defendant is primarily, if not purely, circumstantial. In the face of a motion for judgment of acquittal, the question for the court to determine at this moment is whether the state has produced sufficient evidence to permit the case to go to the jury. That is, could a reasonable trier of fact find guilt based only on the state's case in chief. The state's case here is circumstantial, but the law does not require a judgment of acquittal when the evidence presented is purely circumstantial. A case that is purely circumstantial is different in that there is not always the direct proof that we have in other cases. And there are a couple of older cases that deal with the criminal case being circumstantial evidence. There's a 1918 case, Webb versus State. Issue presented is whether the trial judge had committed an error by failing to instruct the jury on circumstantial evidence. The trial court, the Supreme Court, acknowledged that the case against the defendant was purely circumstantial. The trial court permitted the case to go to the jury. The Supreme Court reversed the conviction not because the trial court let the case go to the jury, but because the trial court had failed to instruct the jury on the law of circumstantial evidence, that is, how to weigh circumstantial evidence. An additional case is Bishop versus State, 1956, Tennessee Supreme Court case. And again, like Webb, the state's case at this trial was purely circumstantial evidence. And again, the Supreme Court reversed, and also not because the state's case was purely circumstantial, but because, again, the trial court had failed to instruct the jury on circumstantial evidence there. In the court's view, there is sufficient circumstantial evidence to submit this matter to the jury for determination. So the motion for judgment of acquittal will be denied. Has Mr. Swift made a determination whether he wants to testify or not?
We're not ready to announce at this time, Judge.
Okay, can we go ahead and let's have our moment inquiry, at least so that he understands on the record what his options are.
We can.
That's for you to do right there. He doesn't have to take a stand. I just need the microphone over there a little bit closer.
Yes, you said now, so I can pick up.
Yes.
Mr. Swift, can you hear me?
Yes.
Can the record hear me? You have the right, you're the defendant in this case. You understand that it is your choice, along with my advice, as to whether you want to testify during our proof. The state has rested. They have presented their case. We will start our case in just a little while after lunch. There will be several witnesses. You understand that you have the right to decide whether you want to testify or not testify.
Yes.
And you understand that that's solely your decision with my advice, and that we've consulted about it.
Correct.
And you always have the right to do that if you want to get on the witness stand. You also have the right, since the state has the burden of proof, you don't have to testify. No bad things can be inferred by the jury from that. Do you understand that?
Correct.
Now, do you agree to keep your mind open and continue to discuss with me through your state's witnesses, through the defense witnesses, whether you want to testify or not testify, and at some point will be required to make a statement about whether we're going to do it or not?
Yes.
All right.
Very good. Thank you. Anything else before we recess for lunch?
As far as the time, we're going to kick off our proof when we come back, and I intend on having it lined up so it can be orderly. Would you give us? Are you saying we're going to come back at Would you give us to
One,
1:30?
I was thinking, do you need more than that?
Would you give us to 1:30, Judge? I promise that we'll make good use of it.
All right, we'll get started at 1:30 then. Be in recess.
All rise.
You can hear it?
Oh, yeah. Yeah.
Williams, okay, go ahead.
The state has not received any reports. According to the rules of discovery, we are entitled to receive reports just as we are supposed to supply those. The state did file a request for reciprocal discovery months ago, and we have never received a report. That prevents us from having an opportunity for our expert to be able to review that to determine whether there needs to be any rebuttal. And it's totally catching us by surprise. We've had no opportunity to review anything.
Well, I've reviewed the court file, Mr. Goodman, and I saw that there was notice of the intent to present the testimony filed some time back, and I don't know whether there's been a report. I did not see a report. I don't know whether there's been a report filed or not.
There has not, Your Honor. There are slides that will aid in during his testimony, sort of like the expert that just testified for the state. We basically received data, and the court appointed Mr. Williams to assist the defense in interpreting the data. And so Mr. Williams has done that. And in fact, the data even came in, a week and a half ago, 2 weeks ago. He's not issued a report. He has prepared slides which show the raw data, just like their expert did, to assist the defense. And we gave that to the state as soon as we got it. And so that's what I would call demonstrative evidence. Has been used to interpret, but their witness has not provided a report. And so, Judge, we were talking about getting things late. I got things as late as this Monday, the day before trial.
Let's just focus on what's in front of us, which deals with one specific.
We did get notice of an expert. However, as soon as we got that, we asked for a report. We were told by the defense that there would be a report, and as soon as we got it, they would get it to us. I've asked them 3 different times for a report, and each time it's been, we will get it to you when we get that. These slides that they intend to show today, they sent these to us last night. We haven't had an opportunity to have anyone look at these.
These slides are just the data that their expert testified about. The slides that he prepared, 2 weeks ago, are basically talking about the same time frame. So we provided what we got, and we're trying to do things to accommodate trying this case, and that's the situation. They had notice. I guess if they wanted to, they could have called and talked to Mr. Williams. Nothing stopped them from doing that. I've done that with state's witnesses before, so we've not had any discovery violations.
I don't think the notice they provided had a name. It just said they had a cellular data. Okay, I'm sorry.
I think the notice did have a name on it.
Yes,
I do believe that it did.
Your Honor, the problem with that is he is going to rely on this, and he did not put any of his findings in a report. Our experts have. You heard from our expert this morning from the computer extractions that he prepared a report.
I know there's no requirement, though, in the law that any expert prepare a report. And it looks like to me that Rule 16 B1B, the defendant has requested disclosure under A1F or G, and the state has complied, and the state has requested reciprocal discovery. But what I'm hearing is that there is not a report. If testimony turns up that there is a report in existence, then that's going to change the way the court views this thing. But the court's going to overrule the objection and let the witness testify at this time.
Thank you, Your Honor.
Are we ready for the jury now?
We are, Judge.
Okay. Let's get them in.
All rise.
All right, they say, y'all sure you're in the right seat now? I hate for anybody to get out of order or anything. Tell me, how's everybody feeling? Feeling good? Everybody feeling good this afternoon?
Yes.
Ready to
Yes,
move
sir.
forward? You good? Okay, very good. Call the first witness.
Your Honor, the defense calls Robin Alford.
Raise your hand. Do you solemnly swear the testimony you're about to give to be the truth, whole truth, and nothing but the truth, so help you God? I do. You may be seated.
Ma'am, would you introduce yourself say your name?
Yes, my name is Robin Alford, A-L-F-O-R-D.
Thank you, ma'am. Let me ask you a few questions. Back in 2010, did you know Karen and David Swift?
I did.
Would you just briefly tell me how you met both of them?
Yes, Karen and I's relationship started off with the connection between our daughters. Her youngest daughter, Keely, and my daughter, Allie, just had a sweet friendship. And so through that connection, Karen and I started doing play dates together and just eventually being together pretty much every day or every other day.
And did y'all, I guess, did you live in close proximity to the Swifts? Or
Well, we both lived in Dyersburg. I would say 10, 12 minutes apart.
did there come a time back in 2010 that you and your husband and David and Karen Swift started doing things socially?
Well, Karen and I's relationship was always family-oriented. Everything we did, it was with the kids. We were both stay-at-home moms, and she was a wonderful mother, and we did so many things together. There was multiple times my husband and I would be around Karen and David and witness it to be a good marriage.
Did you do family activities with the Swift family, you and your family?
Yes, we would go to my dad's farm. We'd go fishing. We would have bonfires. We'd ride four-wheelers. We would take them to water parks. We were on the go all the time. It was so much fun.
Is there a time after that that you and Karen's relationship sort of changed?
I could see that Karen was kind of drifting away from her marriage, and she would speak to me in confidence about not being happy. There was a little shift in her priorities, and so our friendship kind of suffered from that.
Okay. Was there an occasion did you know the Bonas?
Yes.
All right. And can I ask how you knew them?
Kathy was our daughter's dance instructor, and she was also the YMCA fitness person there, that we'd go to classes together there. Karen and I's relationship, we were friends way before kind of Kathy came into the picture, but then we would have swim dates and stuff like that. I was invited to go to Kathy's 40th birthday party. My husband didn't want to go. He wasn't a big fan, so I went with Karen that night. We had a good time.
Did you and Karen drive together, or was there a lot of people there?
She came to my house, and we got ready. We took pictures before. I think we drove separately to the actual venue.
All right. I don't want to go into every detail, but did you attend the Bona's 40th anniversary party?
It was her 40th birthday.
40th birthday party,
yes.
Excuse me. And were there several people there?
At the farms, at the venue, yes, there was.
And after, it was a eat and drink event at the venue?
Yeah, just like a DJ and just a social gathering.
Afterwards, Did you and others go to a different location with the Bonas?
Yeah, that would be their house.
Had you been to their house before?
No.
And did you go along with others to the Bona house?
Yeah, I went because Karen asked me to go, and, you know, it was a fun night, so I thought we'll just see, you know, where the night will take us.
I guess, was there a hot tub involved?
There is outside on their deck, they have a hot tub, and it's not the main focus of the backyard. They have a pretty large deck, and there were several tables, several people engaging in conversation. I would be sitting at a table with other people having a conversation, but to the left of me, I saw the hot tub, and I saw people get in the hot tub.
Were people in different stages of dress or undress?
Yes.
All right. Was that primarily in the hot tub?
Mm-hmm.
Is that yes?
It was, yes, the hot tub. There were people that maybe didn't have bathing suits and got in their undergarments.
And I just want to get through this very quickly, but did you see Karen Swift leave the hot tub and go into the house?
I did. I witnessed her get up. She looked to me as if she was hot and woozy kind of feeling, and I saw her go inside, and it wasn't but a few minutes later I saw Mr. Bona go in as well.
Can I ask this? Was Miss Swift, was she wearing her outfit, or?
That's vaguely something I'm trying to remember. I know when I walked in and I witnessed her laying on the floor, she didn't have anything on her.
All right. Now, she walked, are you saying that you saw Karen Swift walk from the hot tub into the Bona's house?
Mm-hmm.
Okay, is that correct?
That is correct.
And I'm not trying to beat up on you if you'll say yes or no or answer. And after Karen Swift walked in, did you see someone else immediately walk in?
Yes, it was shortly after was Mr. Bill Bona.
All right. And then, as a result, what did you do?
I walked in, I said, "What's going on?" And I got a towel and immediately covered her up, and I said, "Go get her husband right now."
Well, when you walked in, what did you see?
I saw him standing over her, gawking with a creepy look on his face.
Was she clothed, or did she have a towel on her?
I put a towel on her.
Did you see Mr. Bona put a towel and cover her before you walked in?
No.
All right. And did you make some remark, and then how did they react to it?
He just looked very surprised at me, and I was just kind of offended by what I witnessed and covered it up immediately and said, "Go get her husband, please."
And did you see Mrs. Bona in the room at that time, or next in the house at that time?
Nobody was in the house. I vividly remember that.
Was Miss Bona, was she near the hot tub when you walked in the house, or do you recall?
She was outside engaged in conversation.
Okay. And after you made that comment about go get David Swift, where was David Swift, to your knowledge, before you walked into the house?
He was outside at a table, just, trying to fit in, I think, and have conversation with people.
All right. And what happened next? Did someone walk into the house? Did you stay, first off, with Karen Swift?
Until David come in, yes.
Was Karen Swift, did she act like she was either ill or under the influence? Or?
I said, "Karen, are you okay?" And she's just kind of coming out of a state of kind of what's going on. And she said, "Yes, I'm fine." I said, "David's coming to get you and you're going home."
Okay. And then what happened next?
From what I recall, David picked her up, got her belongings. Maybe I carried her to the bathroom and got herself together, I would think, before she went home. But I know that I walked out with them and never returned.
Okay. And to your knowledge, did the Swifts leave either before you or at the same time as you did?
I would say at the same time.
All right. Now, after that, did you ever go back to the Bonas?
No.
All right. Did you have a conversation with David Swift after that about this incident?
David would ask me things, and I think one time he did ask me. I, of course, talked to Karen the next day, and I just said, again, is everything okay? Did, anything happen last night? And she, of course, told me it's fine. And no, everything's okay, Robin. And I said, well, you can always let me know if you need to tell me anything. And she said, I will.
Did she indicate that it made her uncomfortable, or if she felt like she was being threatened?
I told her that she needed to tell her friend Kathy.
All right. After that, did you talk to Kathy Bona about this?
They never once approached me at all and ever asked me what I saw. I know that it got back word to her because she immediately wanted to give me a brushed off feeling. But
You talking about the next time you saw her, you didn't communicate with each other?
No, like I said, my daughter still went to her dance studio, and was it awkward? Yes, but I'm going to call out some misconduct if I see it.
Well, and I just want to go off what you saw or what you observed, not what you think others did.
Yes.
Just to be fair, but after that, did you and Karen Swift have communication and get together sometimes?
Like I said, Karen and I always revolved around family. I even got to see her with her 2 older boys, not just her 2 younger girls. She was a wonderful mom to all 4 of those kids. And I saw a shift in her marriage, and I saw that it was different. Her priorities changed. She would be going out after the kids would go to sleep, and that's not what I wanted to do. And so, therefore, our friendship did take a step back. I was always there for her. She called me on the phone. She texted me. But it kind of, we didn't hang out as much.
Okay. And I guess, did you talk to her, if she went missing, she did go missing on October the 30th of 2011.
Mm-hmm.
Did you have communication with her shortly before that?
I was in Nashville that weekend. I was going to attend a Titans game on Sunday, but I know that she called me Friday night, and she said, just to let you know, the girls and I went and rode your house tonight. Don't be mad, please. We'll even come and clean it up the next day. And we had a good laugh about that, and that was the last time I spoke with her.
Did you, were you aware whether or not, when you first met the Swifts, that they drank alcohol or not?
Karen never drank before she came to Dyersburg, never. And I don't think that she could handle her alcohol at all, not well, at least. It would be just a small amount, and it would give her a different feeling because she didn't have a tolerance for it.
And to your knowledge, while you're with the Swifts socially, what about David Swift drinking?
He never drank. He may hold a beer, and that beer would last all night.
Okay. And at some point, did you tell David Swift what you observed on the party?
I did, and then it got back to Karen, and that's okay because I stated my truth and I saw what I saw.
Okay. Just 1 second. Just 1 second. To your knowledge, I guess in 2011, did you see David Swift with an injury or on crutches?
I did. He brought the girls to me on Halloween of 2011. That's the day, well, she went missing on the 30th. And I took the girls trick-or-treating that night. And he dropped them off because he couldn't get around the neighborhood like we did. And he came back around 10 o'clock that night and picked them up again.
So that was, you had contact with David Swift on the night of October the 30th.
Halloween, yes.
And I guess, was it solely for the purpose of you taking the girls so they can enjoy Halloween?
Just to give them some normalcy, because they asked multiple times that night where their mom was. And we just tried to make it as normal as possible and as fun as possible, which was a very hard task, but we did what we could do.
And he brought them and dropped them off himself?
Yes, he had their costumes, and then I kind of put it together, put their makeup on, and got the rest of them together, but he did. He dropped them off, and he was on crutches.
Okay. All right. Thank you, ma'am.
Mr. Goodman?
Good afternoon, Ms. Alfred.
Good afternoon.
My name's Danny Goodman. I'm with the District Attorney's Office. Ma'am, what did you tell David you saw that night at the hot tub party?
I just told him what I witnessed as far as walking in and seeing Mr. Bona standing over her, gawking somewhat.
Okay. You also, did you tell him that you thought that Mr. Bona was taking advantage of Ms. Swift?
I don't recall those exact words. I just know it was awkward, weird, and creepy.
Okay. Do you remember giving an interview on October 31st, which was the day after Ms. Swift went missing to the Sheriff's Department?
Yes.
Okay. Do you remember telling them about that incident?
I told them about that, yes.
Okay. And you just testified a few minutes ago that she was laying on the floor when she went in.
There was like a pillow, kind of floor pillow, and that's what I saw, or what I remember her laying on. It could be a couch cushion, I don't know. It was just something in the floor.
Okay. And you stated that you went and got a towel and put it over Miss Swift?
I had a towel when I walked in.
And you're the one that placed that over Miss Swift?
Yes.
Okay. Would you be surprised that in your statement the day after Miss Swift went missing that you gave a different statement to the officers?
I'd like to see that.
Okay, I'll be glad to hand that to you. Let me mark the portion for you. Okay, I'm going to hand this to you. If you will look at the last paragraph that's highlighted, I put a star beside it. Would you read that? Wait a minute, Jim. I'm sorry. Yes, the statement that you have. I'm sorry.
Karen woke up and...
I'm not asking you to read it out loud.
Okay.
Did you read it?
Just read it to yourself, ma'am.
Okay, yes, sir.
Did you read that?
I read it,
Okay,
yes.
does that refresh your memory?
I talk about a towel.
Okay, and you actually say that Bill put the towel on Miss Swift.
There was standing there with the towel. Alfred saw a towel on Karen. Maybe I handed Bill the towel and said cover her
Okay,
up.
but that actually says when you came in, you saw a towel on Karen. Is that what that says?
That is not what I recall. And
Is that what the statement says?
it says Karen told Alfred that Bill put the towel on her.
Okay. Did it also say that you saw a towel on Karen when you walked in?
It says Bill was standing there and Alfred saw a towel on Karen.
Okay, so if
But
you
it
saw
does
a
not say
towel on
that I
Karen,
said that.
Just a minute, one at a time. He's asking the question.
so if you saw a towel on Karen, you couldn't have placed the towel on Karen, could you?
Either I or I gave it to Bill to put a towel on Karen. But when I walked in, there was no towel on Karen whatsoever.
Why did you tell the officers it was?
From what I remember, that's not what I said.
Okay. Could you hand the statement back, please? You also questioned Karen about it the next day, didn't you?
I did, yes.
And Karen told you nothing happened, didn't she?
She did.
Okay. And you also told the officers that Karen was coherent that night.
She looked up to me after I walked in and said, "What's going on?"
Okay. Did you tell officers she was coherent at that time?
I'm thinking she was coherent, but that would be me assuming because I don't know what her state of mind was at that time, but she did look at me once I walked into the room.
Okay. Well, obviously you thought you knew her state of mind the next day because do you want to look at the statement?
I believe I remember saying she was coherent because she
Okay.
looked at me in the eyes.
Okay. So if she was coherent and the next day you talked to her about it
Yes.
and she told you nothing happened,
She did.
do you have a reason to doubt her then?
No, I don't.
Okay. Now, David is the one that actually told you that Bill was trying to make a move on Karen, isn't it?
I think he may have asked me that one time.
He didn't tell you that Bill was doing that?
Did he tell me personally
Yes.
that Bill? Not that I recall.
Okay, would you look at the
It could be
statement?
in my statement that maybe he asked, or
Okay, would you look
So
at the
if I
statement
had
just
that-
to refresh your memory again?
yes, sir.
Okay, it is the third paragraph. If you will look to the left, it's the first star. Okay. Have you read that?
I'm reading it right now.
It's only one sentence.
It's okay.
Okay. Does that refresh your memory?
It says David said that, yes.
Okay, so that actually says David is the one that told you that Bill was making a move, right?
But that's not what I recall, because that's why there was an issue with our friendship. It's because they disengaged from me because of what I said or what I walked into, and that I questioned it.
Okay. Well, how would David be able to tell you that Bill was making a move if he wasn't even in the room?
He wasn't in the room.
How would he be able to tell you that then?
He'd asked me about it, and he didn't tell me anything unless if he knew of another time. I don't know. That was just what I recall from that night.
Now, you knew that Karen was going to get a divorce, didn't you?
She texted me around the middle of October, and she said that she had filed for divorce, and my response was, wow, that's a big step.
Okay. And then David was always controlling of Karen, wasn't he?
He was.
Okay. And he was always curious about where she was and what she was doing.
He was.
Okay. And he called her all the time to find out where she was. Right?
Yes.
Okay. Would you agree that Karen really never had a life when she was with David?
Yes. I know when they lived in Arkansas, she was just a devoted mother. She didn't have many friends. And I saw as she moved to Dyersburg and we became friends, and how her circle of friends grew and grew, and she loved that. Karen loved to go and do and be center of attention sometimes. She liked to always have friends, and she wanted to do something with someone every day.
And David didn't want her to do that, did he?
I don't think if he wasn't involved, maybe not.
Okay. Would you agree that David Swift is good at mind games? Your Honor, I'm asking about her statement.
Repeat the question.
Would you agree that David Swift is good at mind games?
I will agree that I said that he is, that she told me he was good at manipulating situations.
I guess the objection was overruled since you went ahead.
I'm sorry, sir.
You made a statement when you were testifying previously that Karen would leave the kids at night after they went to sleep and go out.
Yes.
Did you see that?
I have, yes, there would be times where she would stop by my house on occasions when she was out or
At what
doing
time?
that. It could have been 9 o'clock, it could have been 10 o'clock, but nothing later than that.
Okay, so not extremely late.
No.
Okay. But she never left the kids alone.
No, never.
And you said that Karen could not handle her alcohol. Is that right?
From what I witnessed, she wasn't a big drinker, but when she would, she wouldn't be able to tolerate it very much.
Okay, so if she had been drinking on the night that she came up missing, do you think that she would get out after going home?
Hang on a second.
I'm not going to say.
We're good now, all right?
Yes, sir.
What's the objection?
Do you think if she'd been out drinking?
No, what's the objection?
Speculation.
Yeah, I court agrees. That objection will be sustained. Let's move on.
Okay. You also said that you saw Mr. Swift on crutches. Is that right? Okay. And you said that was on Halloween when he brought the girls over. Is that correct?
Yes.
That was on October 31st of 2011.
Correct.
And Karen was already missing at that point.
Yes.
You didn't see Mr. Swift before that on crutches, did you?
I know. I didn't.
Okay. Thank you.
Redirect.
The prosecutor asked you about the statement that he passed to you.
Mm-hmm.
He asked you questions about that.
He did.
Did you sit for a video interview with the officers?
I did sit for a video, yes.
All right. And did you answer what the prosecutor showed you? Was that, would it be fair to say that was a brief summary of that video?
Exactly what I was looking at was different from the video. I mean, it would look more like a summary, like someone had typed up.
Did you weren't asked to sign that as a statement, were you? That what he passed up to you?
No, sir.
All right.
Your Honor, I'm going to object. These are the same statements and the same type that were presented by the defense.
I think it's fair redirect.
Yes, sir.
Go ahead.
And in fact, to prepare for today, did you listen to the audio tape that was involved in this case?
I did, and I read my transcript too.
And was the summary that the prosecutor passed you a lot shorter than what you had?
It seemed summarized, yes. Summarized, yes.
All right. But you're testifying about what you recall, and you're trying to be as honest as you can.
As honest as can be, yes.
All right. Now, when you saw, I guess if Karen Swift came over to visit you in the evening sometimes, she would surprise you or call ahead of time?
She would call on her way, usually.
And you don't know where, the children weren't with her, were they?
Not some nights. She'd already given them a bath and put them in the bed.
And so somebody else, either David Swift or she left them by themselves. You don't know, but the kids weren't with her. So either David was watching them or she didn't have the kids with her.
Correct.
Let's put it that way.
Recross.
Yes, sir. Ms. Halford, you've put your kids to bed and left before, haven't you?
Yes, I have.
And does that make you a bad mother?
No, sir. And I would not say that she was ever a bad mother.
Thank you.
Ever.
Ma'am, you can step down if I upset you.
I'm so sorry.
You're good.
Thank you.
Yes, ma'am. Call your next witness.
Your Honor, I call Brian Darr. Brian Darr, D-A-R-R. Would you state your name, sir?
Sure, Brian Darr.
And how are you employed, sir?
I'm a forensic engineer with Quality Forensic Engineering.
And would you explain exactly what that means and what your responsibilities would be?
Basically, a forensic engineer investigates. I'm a mechanical engineer by background, so I investigate product failures, whether mechanical in nature, whether it be tire failures or accident reconstruction, things of that sort.
Now, would you mind telling the jury a little bit about your education and training and background?
Sure, absolutely. As I mentioned, I graduated as a mechanical engineer. I worked about 6 years with a tire company where I was a product engineer, designed, developed, tested, manufactured the tires. Also, while there, I worked out in the plant as a plant technical engineer, where I was responsible for tracking down what was called downgrades, basically defects in the tire, and then changing or correcting the problem. From the tire company, I then went and worked for Honda R&D Americas, where I was the tire development or tire project leader for all the North American developed vehicles. I worked there approximately 7 years. While there, of course, Honda works with various tire suppliers, whether it be Michelin, Bridgestone, Goodyear, etc. I got a chance to go into their plants, do quality visits all around the country, actually all around the world. It also afforded me the opportunity to do various testing on tires, on vehicle, things of that sort. And then once I left Honda, I got into this line of work as a forensic engineer.
How long have you been active as a forensic engineer, sir?
15 years.
And this forensic engineering, does it involve examining tires for defects or injuries?
Absolutely.
And would you estimate how many times you may have possibly done that?
I've inspected thousands of tires.
Now, how did that work? Would companies request you to examine a tire to answer questions about quality?
Yeah, we'll say, for example, a typical case would be there's an accident. Through the course of the investigation, they determined that, say, the left rear tire failed, had a blowout, the tread and outer belt delaminated. So then they want to determine why it failed, if you can. So then I would go inspect the failed tire and, do a thorough visual tactile analysis inspection of it and go from there.
Now, besides inspecting a tire, would you sometimes test a similar tire to determine things about whether or not that affected your findings?
Absolutely. I mean, that's actually what I did in this particular case.
Now, let me make sure I understand. Let's just finish your qualifications, then we'll go into your specific findings.
Sure.
Have you testified in court before?
Yes.
Would you just tell us about briefly where and estimate how many times?
I've been qualified in state and federal court as a tire expert. I didn't bring my list with me. I would say approximately 20 depositions, which also counts as testimony. I've only ever actually testified once in court. This would be the second time.
Now, are you from time to time consulted about your opinions about tires and tire defects or tire repairs?
Yes, all the above.
Did this sometimes involve foreign objects in the tire, like screws or nails?
Yes.
Would you elaborate?
Sure. As I mentioned, I've inspected thousands of tires. Just the course of inspecting all these tires, you invariably will get tires that have foreign objects in them, screws, nails, things of that sort. I've had cases in the past where the actual tire failed and they were pointing to the screw in the tire, as being a reason that it was running low on air and ultimately failed. That's different than this case here. The tire didn't fail per se. It just ran flat or was operated in a really low inflation condition.
Okay. Now, we've talked about your background and experience. Have you been called upon to give opinions in writing and examine the opinions of others regarding tires and tire defects and things of that nature?
Yes.
Have you done that several times over the years?
Yes.
Have you been appointed by courts to do that at different times in the past?
What do you mean by courts? Like clients such as yourself, or
right, or the court appointing you as an expert?
I don't know that a court ever has specifically appointed me. A lot of times our primary clients are insurance companies and lawyers.
Okay.
So say there's a tire failure, and XYZ tire shop had just put the tire on. So then their insurance company, their attorney, hires us to, hey, take a look at this, see if you can determine why it failed.
Okay. I would tender him as an expert qualified to give opinions as to tires.
If you'd like to examine the witness.
We need a sidebar before we do that. Mr. Dard, you said that you've only testified once previously in court?
In court, yes.
Yeah, what kind of case was that, if you don't mind?
I believe it was an accident reconstruction case.
Okay, and what was the nature of your testimony?
It was regarding accident reconstruction, like determining how the accident occurred.
Who was at fault? Was a red light run? That sort of thing?
Yeah.
Okay. Do you have a copy of your report with you?
I do.
Okay, would you look at it for me, please? As I read your report, sir, I see on, you start out with our work, we agree, we partially agree, we do not agree. And in fact, in your entire report, I consistently hear, or I consistently read, our opinion, we disagree. Only one place do I see the word I, and then it says I/we. I just want to clarify, Mr. Dar, is this report your conclusions and your conclusions alone, or is it a collaborative effort between you and the rest of the people in your group?
Objection?
Judge, we're about more down on the witness for his qualifications. We're not getting into the findings of his report yet.
I don't think that he is, and I think it's a fair question for this witness's qualifications, whether the work is his or the work is someone else that he's testifying about. So the objection is on the floor.
Can you restate the question again?
Okay, if we can look at your report, I see in paragraph 2, our work to perform this evaluation results in conclusions. We agree. Number 2, we agree. Number 3, we partially agree. Number 4, we do not agree. And then on the next page, we disagree. Go down to subsection B, we disagree. And then go down to, in conclusion 4C, for all these reasons, we disagree. But that's pretty much the theme. I do know there is somewhere in your report where you it does say I/we, but for the most part, it's our or we is referred to when the opinion is given. And I just want to make sure that I'm clear. Is this your work? Are these your opinions that you're testifying to today? Or is it the collaborative opinion of your quality forensic group?
It's absolutely my opinions. The reason I'm putting we is because all of our reports get peer reviewed. So it's not just my opinion. My peer reviewer reviewed this and agreed with me. So
it is a collaborative effort.
It's peer reviewed, yes.
All right. Continuing witness?
Yes, Your Honor.
You want to say anything about that?
Yes.
Court accepted Mr. Dar as an expert in forensic, as a forensic engineer. I said entire failure. That's what I wrote down.
Yes, sir.
Is that a fair way to call you?
I believe so.
Okay. All right, very good. Ladies and gentlemen, I want to be sure you understand. The court did not appoint any experts in this case. If there was any confusion about that, that's not intended. But when I say the court, I mean me. I did not appoint experts in this. Okay.
All right. Thank you, Your Honor.
Yes, sir.
Mr. Dar, once you became involved in this case, can I ask what you received and how you proceeded initially to
go ahead. Yes.
How you proceeded to form your opinion? Okay.
Yes, as I recall, I actually copied all the data I had onto a flash drive, but as I recall from reviewing it, you had sent me a copy of the STL report, the other tire experts report. Within it, it had photographs of the tire in question, tire and wheel in question. There was photos of the subject vehicle, the Nissan, like where it came to rest along the right side of the roadway. I believe there was a few photos of a silver Volvo, which I believe was Mr. Swift's vehicle. There was photos of a white Ford pickup as well that I reviewed. That was the extent of what was made available to me. I think maybe there's a police report, maybe. I don't remember.
All right. Did you also receive a report from the state's expert?
Yes, that was the very first thing I mentioned, the STL report.
All right. If I could pass these. Can I hand you those and just ask you to look at them and see if you recognize these?
Yes.
Okay. Could you just briefly tell us what they are?
They look like close-up photos of the screw in question that's in the tire. Here's a photo of it sticking through.
Well, let's do this.
The air chamber.
Are those true and accurate copies of what you received?
I believe so.
Okay. Judge, I asked those be introduced as an exhibit.
I see them again.
Yes.
You want to look at it?
Well, there's a difference in being true and accurate of what he received and being true and accurate reproductions of the actual tire.
You could look at them and satisfy yourself. Can we have a sidebar?
Okay, go ahead.
Thank you. Mr. Darr, let me get back on track.
Sure.
Were you sent photographs to examine along with the report of the state's individual who examined the tire?
Yes.
Did you review those to review the evidence to see whether you agreed or disagreed with his findings?
Yes.
All right. Can I pass these to the witness?
Go ahead and pass them to him. I need to see Exhibit 21, please.
Can you take a look at those, and when you are through, would you have you examined those photographs?
I believe so. They look like they were some of the photographs originally supplied.
And do they look like they're copies of that were either attached to the discovery that you received from us or from the report of the state's expert?
Yes.
Okay. Now, once you received the report that we sent you and the photographs and the information that we sent you, what did you do in this case?
I reviewed all the information. I reviewed the other expert, the STL report. Went through, I think I originally asked if you had any higher resolution photographs so that I could zoom in better, and the result was no. I believe I asked if the tire was available to inspect. The answer was no. So then I had at one point proposed testing be completed, actually get an exemplar tire. And
when you mean exemplar, explain what you're talking about.
Okay. An exemplar tire is a tire that's similar to the subject tire. So I procured a similar tire, and then I put multiple screws in it where I threaded it in, actually like turning it in, and then two more screws.
Thread it. Did you use a device to do that?
Yeah, I believe I used my drill.
All right.
Yeah.
So you manually did that?
Yes.
And what was the purpose in doing that?
Well, to simulate what in the STL report, he was claiming that the screw was manually inserted into the tire. So I was trying to replicate that.
And do you believe that you did?
Yes.
And go ahead and explain.
Okay. So I put two screws in where I manually threaded them down through the tire into the air chamber side of the tire. And then two screws where I didn't have a wheel for the tire to mount on, so I couldn't inflate it, nor did I have a vehicle to truly replicate it. But the best I could do, so the other two screws, I put in 4 total. The other 2 screws, I actually used a hammer and pounded them through the tire.
Why did you do that?
To replicate a screw being inserted into the tire like you ran over it.
All right. Do you think that would lend you, is that the only way that you can replicate a screw like being picked up on the road or knocked into the tire?
Well, it's not the only way, but is the only way given what I had available.
Okay.
As far as I know.
And have you done that on other tires in the past to find?
Yeah, I've had previous cases that involved a screw in the tire, and it actually involved how long it would take for the head of the screw to wear out. So I had to do testing that basically validated that or invalidated it.
Now, you reviewed the state's expert's report.
Correct.
And how you did not actually inspect the tire in question.
No, I did not have it physically available. I had to rely off his photographs and notes that he took, that the other expert took.
All right. And you had the information that he utilized in the photographs that he utilized.
Yes.
All right. After you did what you did to replicate the conditions between a screw being manually turned in by some device, and also a screw being picked up through simulated road conditions.
That is correct.
And I guess, what did you find when you did that?
Well, I have the findings in my report. Would you like me to read down through them?
Yes. Can we go through those and whether you agreed or disagreed with the findings of the state expert and why?
Okay.
Now, before we do that,
sure.
Those are true and accurate copies of what you examined, to those photographs up there?
I believe so, yes.
And they indicate the condition of the screw. These are the photographs that you received that the state had.
Yes.
And so, would you hold up that first one? What does that depict?
This is a flathead screw in the groove of the tire close-up. You can see the abrasions on the screw, a little spot of rust, some gouging in the head of the screw.
What would, if you'll hold that up and just let me ask, if the tire's moving, could it have some effect if it's an old screw or a rusty screw on the end of the head?
What do you mean?
I mean, if it was a completely rusty screw or old screw, if you're driving on with that tire, with that screw in your tire, could that change the appearance of the head of the screw because it's driving or moving on the road?
Oh, absolutely. I mean, you can see close up there's abrasions all over the head of the screw. So it kind of looked like there was more rust on the screw at one point, and it got abraded off.
Okay. If you'll hold up the next picture.
These two pictures appear to be very similar.
Okay. Are they from any different angle, or do they appear very similar?
They appear identical.
Well, can I have one of them? Just put one of them off to the side.
Okay.
And what's the next picture you have?
This is on the air chamber side of the tire, the actual screw poking through.
And I guess, what do you notice about the appearance of the screw in that photo?
It's very rusty, very weathered.
Okay. Could that indicate it's anything about the age of the screw, or can you really tell?
Well, it appears old just because of all the rust that's apparent. The tip, it doesn't appear that pointy. The tip is kind of dull. So, definitely looks like an older screw.
All right. If you'll put that down and go to the next one. Is that the same picture?
Yeah, that's what I was saying earlier. These two appear to be
it's
identical.
my fault. Yeah, let me have the two photographs that you examined. Keep the duplicate of that one.
Okay.
And the one with the rusty screw.
Okay.
Let me have it.
Oh, you want all of them?
Yeah. Okay. Your Honor, I would ask that these be made an exhibit.
Any objection to those two photographs?
No objection to those two photographs.
Okay, that'll be 36, I believe.
All right. Let me ask you about, I guess, your findings and conclusions based on your examination, your test.
Okay. Yeah, what I would propose is to read down through my conclusions that were listed in my report.
However you would like to do it. Let's take it one at a time. What is your first conclusion?
Okay. So the way I did the conclusions within my report, so the STL report, the other experts report, had 4 opinions. 4 opinions, and conclusion 4 had 4 parts or 3 parts. So I basically addressed each one of his opinions in my report. So the first conclusion that I have, we agree with conclusion 1 of the STL report that there was no design or manufacturing defects with the subject right front tire of the Nissan.
Okay. And what was your next item that you concerned yourself with?
Conclusion number 2, we agree with conclusion 2 of the STL report that the subject tire was severely damaged from being operated with low or no inflation pressure.
Okay. So you agree with the two conclusions of the other expert on the first two
Correct.
items. All right.
Correct.
And the next?
Number 3, I stated we partially agree with conclusion 3 of the STL report that loss of air was from the screw that was in the tire penetrating into the air chamber. While the loss of air due to the screw is likely, I couldn't see within any of the other experts' notes or anything that he actually did air testing. Air testing in and around the screw, where you would kind of pressurize the backside of the screw, say with a pipe, and then put soapy bubbles on the exterior surface, and then if there's a leak, you'll see bubbles form. That was not done.
Now, I guess, why is that important?
Well, it would just help you kind of quantify, so to speak, was it a fast leak? Was it a slow leak? I mean, do a lot of bubbles form? Does it barely form? Just to give you a better idea of, what you're dealing with here.
All right. And I guess the next conclusion or result that you reached.
Okay. So this one would be for A. Like I said, their results had 3 parts to their conclusion 4. And this will get kind of wordy because their conclusions were rather long.
Well, let's talk about item number 1 under that topic.
Okay. So based on the photographic evidence and the physical testing that was completed, we do not agree with conclusion 4 along with its 3 sub-bullets in the STL report. Conclusion 4 in the STL report stated the following. The screw is oriented perpendicular to the crown of the tire. When a puncture occurs in service, the penetrating object pierces the tire at an oblique angle. This phenomenon results due to the curvature of the tire and the flat surface on which the tire rolls. My comment to that was, it's plausible that a screw could be inserted at perpendicular or straight angle through natural acts of driving down the roadway. And we disagree with conclusion 4A of the STL report.
Now, perpendicular, are you talking about if somebody made the statement that in order for a screw to, puncture into the tire, does it always have to be standing up, or are there exceptions in your experience?
Based on my experience, there's many exceptions. I mean, you can have the screw be straight up at an angle this way, angle that way, angle forward, angle back. I mean, the possibilities are limitless. I mean, you have a road surface that's not necessarily smooth. Everyone's driven over potholes and things of that sort that's in the asphalt. What if a screw gets down in one of those potholes and is pointing up at an angle and you run over it? I don't know. I mean,
would
it's
that
possible.
Now, when you say perpendicular, do you mean at an angle?
Perpendicular typically refers to, perpendicular means that the nail was 90 degrees from the surface of the tire.
Okay. Now, you talked about the road, the asphalt surface, and how that could make exceptions. What about things like rocks or gravel or other vehicles?
Absolutely. I mean, there's other vehicles could kick up screws or nails. Say you're following a construction vehicle and some are on the back of the trailer and they bounce off and you just happen to be behind it. You could pick those up. Who knows what angle it's going to strike your tire at as you're going down the roadway.
And is it possible that if it does strike your tire as you're driving down the roadway, that it takes a while to work into the tire?
Yeah, absolutely. Again, it's all dependent on the way it could bounce, the speed you're going. There's a lot of variables, factors that, too many to really account for.
Now, if the other expert made the statement that all the moon and the stars would have to be aligned before it's possible for a screw to be kicked up or to go perpendicular into the tread or tire, would you agree with that, or how would you What is your opinion?
I wouldn't necessarily agree or disagree. I mean, yeah, I think it would be, things would have to align to be just right, but again, I think it's possible. Again, as I mentioned, you have irregular road surfaces, screws could be down in the irregularities, pointing up at a given angle. They could be bouncing down the road if they fell out of the vehicle in front of you. I mean, there's lots of different possibilities.
The next conclusion of that you addressed.
Okay. Conclusion 4B of the STL report states, the head of the screw is below the surface of the tread ribs. Because of the elastic nature of a tire, a penetrating object will be pushed out slightly as it exits the footprint of the tire. Consequently, the object will remain slightly above the surface of the tire until it's worn flush with the tread rubber. This did not occur. And my response to that was, it is plausible that a stone could be driven over that would fit up within the groove where the screw is located. When this occurs, the stone will contact the head of the screw, and the weight of the vehicle would push the screw farther into the tire, below the surface of the tread. We disagree with conclusion 4B of the STL report.
Now, when you say that a stone could engage with the screw and push it up, and even if it was originally perpendicular, sticking out of the tire, are you talking about it could be struck by a rock and drive the screw further in the tread?
Correct. The way I take his conclusion is that, well, the head of the screw is below the surface of the tread. So he's saying that can't happen. But very simply, I believe it can for the reason I just stated. I mean, as an example, I was thinking about this when we had the recess earlier. I went to a local restaurant, Reggie and Richie's Barbecue. Their driveway is a 100-foot long gravel driveway. I'm not a betting person, but I'm sure at least one of those pebbles went up in between the groove of my tire as I drove over it. If this screw was in there, it would have pushed it up further.
Now, I guess in that exhibit that we've introduced showing the screw head with the mark on it, could that possibly, what you're talking about there, about being a reason why the screw head has some damage to it or some mark on it?
Yes.
Is that consistent?
Yeah, I believe so.
All right. Now, regarding the next conclusion or result in their expert's report, are there any more?
Yeah, the last one, conclusion 4C. When a tire is punctured in service, the puncturing object is pushed through the tire, resulting in localized tearing and broaching of the liner at the point of penetration. No such damage has occurred where the screw passed through the inner liner in this tire. Instead, the material surrounding the screw inside the tire conforms perfectly to the screw shank. This can only be achieved by twisting the screw into the tire as one would normally do with a screwdriver. And then my response to that, based on the physical evidence obtained from testing, this is not true. From the testing completed, number one of the screws that was threaded turned into the tire.
Are you saying threaded by you?
Yeah, threaded by me, turned into the tire, screwed into the tire. Had a jagged and torn edge of the inner liner adjacent to it. Yet it looked completely fine from the opposite side. And the reason I was stating that, so in the STL report, he literally has, there's one photograph of the screw sticking through when he took it. But that photograph you gave me earlier, that was the one photograph. So you only see one side of the screw, just like you're only seeing one side of my finger. Well, there's the backside too. So when I did the testing of screwing a tire in from the one side, it didn't look torn, it didn't look jagged at all. But on the other side, it was torn and jagged. And, I'll never know the screw in the subject tire, what it looked like on the backside, because there was only one photo taken.
Now, when you I guess when you did your testing on the replica tire, did you examine it to determine if it was consistent with their opinions or not? And were you able to take photographs or to take photographs that differ from their experts?
Oh, yeah. After I inserted the screws into the tire, like I said, I put 4 screws in the tire. After I did that, I took photographs of the exterior and then got into the interior or air chamber side of the tire and took photographs all around the screw just to document it. Do you want me to keep going with the my conclusions?
Yes, sir.
Number 2 of my conclusions of that conclusion 4C, one of the screws that was hammered through the inner liner did not have any disturbed, broached, torn, or jagged inner liner adjacent to the screw. And then number 3, additionally, the STL report only had a single photograph taken of the screw penetrating the inner liner. Therefore, only one side of the screw and inner liner interface was visible. The back side of the screw and inner liner interface was not visible. Based on the testing conducted, one side of the screw and inner liner interface can look undisturbed, while the other does not. For all these reasons, we disagree with their conclusion 4C.
Okay. So I guess in conclusion, are you saying that if their experts said that that screw was screwed in there manually, and it would be impossible for that screw to be perpendicular in the tire other than manually, are you disagreeing with that?
Yes, I disagree.
You prepared a report with your findings and also the photos that were attached?
Yes.
All right. Can I pass this to the witness?
Thank you.
Do you recognize what I just handed you?
Yes.
And what is that?
It's a copy of the report I issued on March 25th, 2024.
Okay. And is that
I have no judgment, sorry.
all right. Can that be made an exhibit?
It'll be admitted as number 37.
Just 1 second, Judge. In addition, were you also sent some photographs to examine a tire versus a tire track?
Yes.
And would you, let's see. Can I hand these to you? Do you recognize those?
Yes.
And I guess, would you just tell me what what they are.
Okay. This looks like it's the right front of a white Ford pickup. You can kind of see the right front tire of it. That was a Maxxis Mutter buckshot tire. Here was tire imprints in the mud, various tread patterns within the mud. And then the third one, here's a close-up of the, looks like the tire that was on the white Ford pickup.
And I guess are those exact copies of what you received?
I believe so.
All right. And I would ask that those be made an exhibit.
It'll be marked as number 38.
Were you asked to examine the tread, compare the tire and also the track that was taken?
Yes, I was given photos of tread imprints in the mud and asked to see if I can identify these or match these up to existing vehicles that they know of.
And I guess is that what you were asked to do?
Yes.
In those photographs, can you make a comparison?
Yes, I was able to.
And what did you determine?
Well, I stated in my conclusions of my second report, the conclusion number 1, tire track imprints were identified that were a positive match for the Maxxis Mutter buckshot tread design. And then I go on parentheses, it's a 4-rib design, high void, with 2 center ribs consisting of S-shaped tread blocks. And then the second conclusion, tires with this Maxxis Mutter buckshot tread design were present on all 4 positions of the white Ford F-250 that reportedly belonged to Mr. Hogsshooter.
Now, so you compared those, and you can tell from the picture of the tire, is there enough of a sample for you to give an impression or give an opinion?
Yes.
And is it your opinion that that tire of Mr. Hogsshooter's vehicle made that track that's in that photograph off of the end of Willie Johnson Road?
Well, I don't know if his vehicle made it, but I know the tires with that tread pattern that's on his vehicle did make it.
That's fair.
Yeah.
So is that consistent with what's shown in the tire track picture?
Yes.
All right. And did you prepare a report based on that?
Yes.
All right. Have you given opinions about tire tracks versus identifying tread to tire marks before?
Yes.
Have you done it several times?
I believe so. Not specifically tires in the mud or tread imprints in the mud, but like skid marks or sliding marks on the asphalt. And does that align with, say, a particular tread pattern of a vehicle? Yes.
So you have enough sample to say that the tire on Mr. Hogsshooter's vehicle compares with the same tread pattern as what is seen in the picture in the mud?
Yes.
All right. Hand that to the witness. Thank you, sir.
Thank you.
And is that a true and accurate copy of your report?
Yeah, looks like it.
Just take a look, make sure.
Yeah, all pages are here, and my resume is at the end of it. Yes.
Your Honor, ask that be made an exhibit.
Be received as number 39. You finished?
One question.
Yes, sir.
I pass the witness.
Mr. Box, before you start your cross, you mind if the court takes a break for about 10 minutes?
No, Your Honor, not at all.
All right, very good. Ladies and gentlemen, don't discuss the case back in the jury room. Do not form or express an opinion. We'll come back in about 10 minutes, okay? All rise.
Jury's coming.
All rise.
All right, let's all be seated. You can have a seat too, sir. Everybody feeling good this afternoon? Everybody good? By now, you know that 10 minutes is a relative term in the law. It's in the same category of a lawyer saying, I just have one question, which you've also learned, is just relative. I don't say it's not true, it's just a relative thing. All right, Mr. Box, I think you were getting ready to start your cross. Sir, you are still under oath.
Mr. Dar, you made a statement on your direct examination that you inquired about examining the actual tire in this case, and you were told no. Who told you no, sir?
I would have asked the client. That was my understanding, that the tire wasn't available.
You'd agree with me that having the actual tire to examine is a preferable way prior to issuing a report?
Yes.
Okay. Let's just go back, if you don't mind. Basically, you and Mr. Bolden don't agree. You don't have completely divergent views. You just have some disagreements with them, correct?
Yes.
You agree there's no defects or manufacturing defects or design defects?
Correct.
Is that true?
Yes.
Okay. And you agree that the tire was severely damaged. It had run flat damage, correct?
Yes.
Okay. What's your opinion on how far this tire had been driven flat?
I didn't make an opinion in here. I would say based on damage, upwards 3 to 5 miles.
Okay. Now, you're familiar with when a tire's been run flat for as long as this one has, and the inner liner is corrupted, breached, that sort of thing. Isn't it true that if you tried to inflate that tire after severe run flat damage, you would likely encounter all sorts of holes and air leaks in that tire because of the dissipation of the inner liner?
Yes.
So if Mr. Bolden had actually tried to reinflate this tire, he could have expected many holes in the tire, that he would not have gotten a true and accurate representation of how that screw in particular leaked air.
Yes. If you're truly trying to inflate the tire on the wheel, yes. What I was referring to earlier, there's a technique that you can use to basically put a pipe with an airline to it, put it right over the screw, and then you supply pressurized air just around the screw, and then look for soapy bubbles on the other side.
Around the screw?
Yes.
You're not talking about on the sidewalls where all the run flat damage is?
Correct. I just wanted to see if if air was actually leaking around the screw.
Okay. Given the hypothetical, you saw the tire and you saw the screw and you saw how it conformed to the inner liner.
Yes.
Do you have an opinion, if that screw had been encountered in service, how long would it have taken that tire to go flat if that was the only defect in the tire?
I don't know.
30 miles, 80 miles?
Well, I don't think it's a question of mileage. It's a question of how long the tire's inflated.
Okay. 15 minutes, 20 minutes?
I don't know.
You saw the run flat damage.
Well, I saw the run flat damage, yes. So that's just an indicator that the tire was being operated with low or no air.
Okay. So am I correct in stating that you don't have an opinion on how long it would take the tire to have gone flat if that screw were the only defect in the tire?
Well, again, it depends what the inflation pressure was at the time.
Assume it was 33 PSI.
Okay. And what's the temperature outside? There's a lot of variables I don't know.
October, 50 degrees.
There's a lot of variables I don't know.
So you don't have an opinion?
No.
Right down. Okay. Now, on your number 3, you basically said a screw could enter a tire in service perpendicularly.
Yes.
You say it could happen.
Yes.
Okay. I'm sure you remember back when you were in engineering school, you took mechanics and you had to draw diagrams and with math and explain your conclusions.
Yes.
Okay. Did you do anything like that in this case to show the jury how a screw could enter a tire in service perpendicularly?
No.
Okay. And lastly, on that point, you further testified that once we had a tire or screw in a tire that had entered perpendicularly in service, that it's feasible that it could run over a pebble or a small stone and it hit that screw head precisely, and that could account for the head of the screw being below the tire tread surface.
Yeah, that's just one example, yes.
Okay, so we have two extremely rare events. Would you agree with me that you're saying could have happened in this case?
I don't think they're that rare. I mean, they actually make tires designed with what's called stone ejectors because it happens so often.
Okay, well, now that's not the same. Now, I understand in your report you talk about the concept of stone drilling, but you're not alleging that that happened here, are you?
No.
Okay, what you're alleging is that this tire was rolling down the road in service with the tire, with the screw in the tire, and that the screw head could have been above the tire tread, and it just precisely hit a stone right on that tire screw head, and it drove it in. And you're telling me that's not an uncommon occurrence?
No, I don't think it's uncommon.
Okay.
Again, the example I gave earlier, I drove down approximately 100-foot long driveway that was all gravel. I'm sure at least one of those pebbles in that gravel driveway went up through into the groove area of the tires on the vehicle I was driving, and if I had a screw in it, probably would have pushed it up further. And that's just a 100-foot driveway.
Okay. And just to close, you did a number of experiments with where you hammered screws into a tire and then you screwed some screws into the tire with your drill. Now, isn't it true that that tire was not inflated?
Correct.
And you'd agree with me that when a tire is in service, that the surface of the tire has a uniform pressure exerted upon it by the tire, by the air in the tire.
Yes.
Okay. And you attempted to recreate that with wooden blocks in a tire.
Yeah, I just put the wooden blocks in there for reinforcement because obviously the tire is flexible with no air in it.
And you consider doing a test on an uninflated tire with wooden blocks the equivalent of a fully inflated tire in service?
For this specific instance, it's the best I could do. And specifically, we're looking at how the inner liner deformed around the object penetrating through it. So in this case, yes.
It was the best you could do. Thank you.
I'm sorry, did you say one question?
No, more than one. Thank you, Judge. Now, let me ask this. The prosecutor asked you about engineering school. You are a professional engineer?
I am, in 15 states.
And how is a professional engineer different than an engineer?
Well, you have to be an engineer to become a professional engineer. In fact, there's 5 steps to become a professional engineer. You got to graduate from an accredited university with an engineering degree. You have to take the fundamentals of engineering exam, which is a 8-hour grueling exam. Hope I never have to do it again. You need 4 years experience. And then you take the principles and practice engineering exam, which is another 8-hour exam. Very bad. Hope I never have to take that again. And then you apply to the state board to get it. So once you complete all 5 of those steps, and assuming the board accepts you, you become a professional engineer.
Is there a continuing requirement, educational, each year for that?
Yeah, each state has their own requirements.
And what state are you in?
Well, like I said, I have 15 states, whether it be Ohio, Tennessee, Louisiana, etc.
You don't have to name them all, but you're accredited in 15 states?
Yes.
Including the states around here?
Yeah, all the states in the Southeast, Texas, Arkansas, Louisiana, Mississippi, Alabama, Georgia, Florida.
Tennessee?
Yes.
Okay. Now, the prosecutor asked you if you didn't prepare diagrams to show, I guess, why you reach your conclusions as to the screw. Did the other expert do that?
Not that I'm aware of.
And if you received all the materials that he submitted in his opinion, did those include any diagrams?
They did not.
Okay. Thank you, sir.
No further questions.
All right, sir, you step down. Thank you, sir.
Thank you. I leave this here.
Let me have those. I think we split two. That's the duplicate, I think. Okay. That's yours, Mr. Taylor. You can get to Mr. Taylor.
You can never have enough pictures. So.
I understand. All right, sir. Call your next witness.
J.E. Reed, R-E-I-D, I believe. Good afternoon.
Good afternoon.
Would you tell everybody your name?
My name is Elizabeth Reed.
And how are you employed, ma'am?
I'm employed by the Tennessee Bureau of Investigation as a special agent forensic scientist in the latent print unit.
Would you tell us a little bit about your educational background and experience?
I have a Bachelor of Science degree in chemistry and mathematics. I completed a 2-year formal training period with the TBI in the development and comparison of latent prints. I completed the TBI's basic forensic science school. I have attended numerous classes and conferences in the field of latent prints. I've taught latent prints in crime scene schools and in criminal investigation schools. I'm a member of the Tennessee Division International Association for Identification, where I serve as the committee chair for the Latent Print Certification Board, and I'm also a certified latent print examiner.
Do you examine fingerprints to compare them to see if you can either identify fingerprints to a known individual or exclude them?
Yes, I do.
Would you briefly just tell us just a little bit of how that's done?
In our laboratory, we analyze evidence for the presence of latent prints. If we find any latent prints, then we will compare them to any individuals in the case. And we can also put them in our APHIS NGI system to search against the database.
Now, the system that you put them in to compare, is that sort of like an electronic photograph that compares them to other jurisdictions in the federal system?
APHIS is the automated fingerprint identification system, and it's a database of all the fingerprint records in the state of Tennessee. NGI is the federal database which houses all of the fingerprint records in the nation. And a latent print would be digitally entered into each of these systems and search against all of the fingerprint cards and palm print cards in those databases.
I tend to her as an expert as to fingerprint identification.
No objection.
Thank you.
All right.
Were you sent in 2012 some evidence to examine for fingerprints?
I received some evidence in 2011.
Okay. And did you issue a report in 2012?
Yes, that's correct.
And could you tell us, was that from the Dyer County Sheriff's Department or the TBI that you received the evidence?
I received the evidence from David Fisher from the Dyer County Sheriff's Department.
And would you just briefly state what you were sent and what you were asked to do?
I was sent a vehicle, a Nissan Murano 2004. I also examined 2 cell phones from that vehicle, and I was asked to look for latent prints on that evidence.
Now, did you actually receive or go into the vehicle yourself to take fingerprint examples?
Yes, I processed the vehicle myself.
Were there others that were you just concerned with fingerprints, or were you concerned with any other items?
My job was to look for fingerprints, but I worked with other scientists who looked for other evidence in the vehicle.
Was this sort of a team that looked through the car? You were assigned fingerprints and other members were assigned other duties?
Yes, that's correct. We worked together on the vehicle.
And are some examples could be DNA? That's not what you examined. Other members of the team, DNA, fiber, blood, things of that nature?
Yes, that's correct.
And did you find some, some fingerprints to examine?
When I processed the vehicle, I was able to find 2 identifiable fingerprints and 3 identifiable palm prints.
Okay. And were you sent examples or subjects to compare them to?
I was sent known finger and palm impressions of David Swift.
And did you compare those known fingerprint? Is this like of both hands? And is this all types of examples of his fingerprints that were taken by law enforcement?
Yes, I was sent fingerprint cards and palm print cards.
Were these done by the Dyer County Sheriff's Department?
They were submitted by Glenn Cook from the Dyer County Sheriff's Office.
Okay. And where in the vehicle did you find your fingerprints when you processed it? Or from what items did you process your fingerprints that you compared David Swift's fingerprints to?
I found prints on the driver's side back door interior window. I also found prints on the interior handle of the front passenger door. And also on the back driver's side door interior on the metal frame.
Okay. And did you compare those examples that you took out of the car yourself to the known fingerprints of David Swift?
Yes, I did.
And did you reach some conclusions?
Yes, I did.
Would you mind sharing them with us?
All of these,
is that only as to the vehicle?
These were all on the vehicle itself.
Okay, go ahead.
All of these prints were compared to David Swift, and all of them were excluded.
Okay. Did you also examine a cell phone from the vehicle?
Yes, 2 cell phones from the vehicle.
Okay. And did you obtain fingerprints from both of those cell phones?
Both of the cell phones had some ridges on them from a fingerprint, but they were too little to do anything with, and so I was unable to even make a comparison with those.
Okay. You have to have a certain number of ridges or distinguishing factors on fingerprints in order to compare?
You have to have several things. You have to have enough area, enough clarity, individual characteristics to compare a fingerprint.
So you weren't able to compare those because of the sample was not sufficient?
That's correct.
But you attempted to compare them and you could not make a match because of the sample?
Well, if we determine that a print is not identifiable, we don't go to the next step of comparison. We just stop there.
Okay. And did you label these as exhibits in your report, these different items that you talked about so far? The Murano, did you label it a certain exhibit in your report?
Yes, in my report, it's Exhibit 01.
And the cell phone, the 2 cell phones, are they numbered as exhibits?
Yes, one is 01-H, and the other one is 01-I.
Okay. All right. And when you completed your examination, you prepared a report that you submitted and signed?
Yes, I did.
All right. Can I pass this to the witness? Thanks, sir. Can I ask you to review that? You recognize that?
Yes, I do.
Would you just tell us what it is?
This is a copy of the report that I issued on January 31st, 2012.
Does this report contain a comparison of the fingerprints that you just talked about?
It contains the initial work that I did in this case, examining the vehicle and the cell phones, and APHIS searches.
Okay. All right. And is that a true and accurate copy?
Yes, it is.
I asked that be made an exhibit.
No good. It'll be admitted as number 40, I believe.
Ms. Reed, later on, or you submitted other items from the Dyer County Sheriff's Department regarding David Swift to examine?
Later, I was given the known finger and palm impressions of David Swift to compare.
And when did you receive those?
These known impressions were received June 22nd of 2018.
Okay. Can I make sure I understand, and maybe I missed it. On the earlier report you did, that was several years earlier. Is that correct?
Yes, that's correct.
And at that time, did you receive known finger and palm impressions of David Swift?
Not with the initial evidence that I received.
You're talking about, I thought you just testified that you received fingerprints back then from the Dyer County Sheriff's Department.
I received the initial evidence in 2012, And then in 2018, I received the known finger and palm impressions of David Swift.
In the earlier report, though, didn't you compare what the Murano and the items in the vehicle with what you received from the Dyer County Sheriff's Department of David Swift, his fingerprints?
In the first report, I did not have the known impressions of David Swift.
Are you saying you had some fingerprints earlier, but you didn't have other examples?
I developed latent prints on the evidence, but I did not have any known impressions to compare them to at that point.
Okay. So is that why you requested some additional prints?
Yes, that's correct.
And were these more thorough prints that you requested that showed something different from the earlier examples you compared to David Swift?
On my original report, the standard procedure is to ask for known impressions of any individuals that might be associated with the case. And so that is in my report, but they were not submitted until 2018.
Okay. And so when they were submitted, this last one in 2018, did you compare these further fingerprints of David Swift to, I guess, some items that you took earlier?
I compared them to the latent prints that I developed on the vehicle back in 2012.
Okay. What about the two cell phones?
I didn't make any comparison with those because the quality was so poor that I couldn't do anything with them.
I understand. And so did you compare the examples you got in 2018 of David Swift's fingerprints with the Nissan Murano, I guess, fingerprints that you obtained?
Yes, I did.
And would you just tell the jury what you found?
When I compared those, all of the latent prints were excluded from the known impressions of David Swift.
All right. Were you given any other fingerprints to match or to compare to the Nissan Murano that belonged to Karen Swift to compare?
No, I was not.
Okay. And did you prepare a report of your examination in 2018?
Yes, I did.
And can I hand you this? I'm making you earn it. So. Can I ask you to recognize that?
Yes, I do.
And is that a true and accurate copy of the report that you issued about what you just testified about?
Yes, it is.
That excludes David Swift's fingerprints from what you found in the Nissan Murano that belonged to Karen Swift?
That's correct.
All right. I asked that be made an exhibit.
Be received as 41.
That's all I have for this witness. Thank you.
Good afternoon, Agent Reed.
Good afternoon.
So you never got a fingerprint standard from Karen Swift?
That's correct.
So it's entirely possible these prints that you lifted off the Murano were those of its principal driver, Karen Swift?
Yes, that is possible.
More questions?
Just one question. I'll keep my word. Did you receive any fingerprints from a person by the name of Mr. John Hogshooter to compare to the fingerprints in the Nissan Murano that belonged to Karen Swift?
No, I did not.
Thank you.
All right, ma'am, you may step down. Thank you very much. Call your next witness.
Doug Somerville. should work. Would you tell everybody your name, sir?
My name is Doug Somerville.
Back in 2011, were you employed at a company?
Yes, I was employed by Tenaris.
And what was your job duty or position at that time?
My job title was maintenance coordinator. I was responsible for maintenance on the finishing end of the mill, primarily focused on what was referred to as the tooling line.
Had you been there for a few years back in October of 2011?
In October 2011, I had been there about 14 months.
Now, you worked at Tenaris.
Correct.
Did you know David Swift when he worked at Tenaris?
Yes, I did.
And I guess, how did you know him? In what capacity?
David was the manager over the production line that I had maintenance responsibilities on.
Did y'all have interaction with each other at times?
Sure, pretty much on a daily basis.
And would you describe your relationship as a work relationship or a close personal relationship?
It was a work relationship.
You observed him doing his job?
Yes.
And you consulted with each other to make sure you...
Objection leading.
Okay, I won't lead. I like that. All right.
Sustained. Go ahead.
You saw David. Did you see David Swift when you would be working?
Yes.
Prior to October the 25th, did you see David Swift or know that he had some sort of physical injury?
Yes, I knew he had knee surgery.
Did you know what period of time before October the 25th of 2011 exactly?
My best recollection, it was 3 to 4 months prior when he had the surgery.
And I guess, how did you know he had surgery? Either from observation or, I guess, how?
Well, I knew it was announced he was going to be off work for a while because of his surgery. And then when he returned, he was on crutches and wearing a brace.
And prior to October the 25th of 2011, did he appear to use his crutches? And
yes.
And did he appear prior to that date that the surgery had some effect on his ability to walk and to do his job duties to a certain extent?
Yes, I would say so.
Now, did you have an occasion sometime in October 25th, 2011 to observe something regarding David Swift?
Yes, I did.
And would you just tell the jury what you saw, what you did?
We had a meeting about maintenance activities that were going to be going on the production line. Meeting broke up. David got up from the table and started walking away, and I yelled at him to grab his crutch. And he said, "The doctor wants me to walk without the crutch."
Objection. Hearsay.
Let's just testify about what you observed.
What I observed on it? Okay. So David proceeded to the bathroom without using his crutch, and as I exited the meeting room, David came out of the restroom, and he and I got involved in a conversation. And less than a minute into the conversation, David just collapsed to his left side. And I grabbed him as he was falling, helped him get back to his feet, and asked him if he was okay, and helped him get up against the wall for some stability, and I went and got his crutch for him out of the meeting room.
From his physical demeanor, did he appear that his leg was causing him distress after he fell?
Yes, he had his jaw was clenched, and he had his face was sort of contorted like he was in some level of distress. Yes.
Did you bring his crutch to him?
Yes.
And then what did you observe after that?
After that, he went his own separate way using the crutch to walk with, and I went my way.
Did you see him back at work after that at some period?
Yes.
And did you see him, you notice anything about him using how he walked or his difficulty?
Well, he was always using the crutch after that, and, you know, at least for a few days after that instance, he seemed to be favoring his left leg a little bit more than what he had been before.
When you say favor, do you mean, what do you mean? Do you mean, what do you exactly?
Walking gingerly on the left leg, taking it easy. I just didn't feel like he didn't appear like he was comfortable with his left knee.
All right. Do you recall, I guess, when his wife went missing shortly thereafter?
Yes.
And I guess, how did you, I don't want to ask about hearsay, but did you know about it because David returned to work at some point?
Found out about it, I guess, from news reports and the fact that David was not going to be at work for a period of time.
Now, when you heard about the report of his wife missing, did this injury that you, this re-injury, or what you saw as he fell down that you just described, did it occur before the date that his wife went missing?
Yes, it did.
And you're sure about that?
Positive.
Now, before what you observed, the date of when you saw him go down or would be re-injured, did you have an occasion to know that David Swift was getting divorced, or that, you know, that was going on?
Yes.
All right. And would you just briefly describe how do you knew that? Did you walk, you know, how you found that out?
I found that out from David one Monday morning.
And can I ask, did you walk to where he was, or how did you find that out?
Well, it was early in the morning. I'd just gotten into work. I noticed David's office light was on, and I needed to speak to him about some things. So I walked over to his office, and when I got there, he just didn't look right. Looked like he hadn't slept all weekend. And I asked him what was wrong, and he told me that his wife and daughters were down in Florida and that they were going to get a divorce.
And I guess, did you talk to him about finances or anything?
Well, he mentioned to me that his wife had emptied out all their bank accounts, and he didn't even have enough gas to get home.
And as a result, did you do anything?
I loaned him $100.
All right. And was that before he was re-injured?
Yes.
Okay. Thank you.
Afternoon, Mr. Somerville.
Afternoon.
My name's Danny Goodman. I'm the district attorney. Let me get this straight. You said that he had surgery months before his wife went missing. Is that right?
Yeah.
Okay. And you said that he was always using crutches after that.
Yes, that's my recollection.
Okay. Did when he came back to work from that surgery, was he using crutches?
Yes.
Did he use those crutches all the way up through October?
He went to using one crutch shortly before, let's say, the beginning of October.
Okay. But he was using crutches constantly. That
Yes.
is from the surgery months back up until October.
Correct.
Okay. And you're saying that he collapsed on the day before his wife went missing?
No, I'm not saying on the day before.
What day did you say that happened?
It was approximately a week prior to her going missing.
Okay. Did you see him get injured?
No.
Okay. So was this collapsing of the knee related to the previous surgery?
I believe it was.
Okay. It wasn't because of a new injury?
Not to my knowledge, no.
Okay. And you said he favored his leg for a few days after that?
Yeah, more so than he had been.
Okay. Did he use crutches then?
I'm sorry?
Did he use crutches after that?
Yes,
How many?
one.
Still used one.
That's my recollection, yeah.
Okay. And when you found out about David getting the divorce, that was in early October?
That sounds right.
Okay. And he was using crutches at that time?
Yes.
Okay. But you did not see him have an injury, a new injury to that leg?
No, all I experienced was the instance I relayed.
All right. Thank you.
Would you describe what you observed and when he went down?
Well, David was standing in front of me, and it was just sudden collapse, and it looked like he was going to the floor, hit the floor. I leaned over and sort of grabbed him around the chest and helped him get back up.
Did it appear that he either turned or twisted his leg or ankle to you? Or do you know?
I don't recall us any movement or anything else. To my recollection, we were both standing stationary on both feet, just talking.
Did this happen very quickly?
Yes.
And you aided him and helped him get back up?
Yes, that's correct.
All right. Did you help him up?
Yes.
All right. That's all I have.
Nothing.
Sir, you can sit down. Thank you.
Thank you.
Go ahead and call your next witness.
Nathan Lane. Nathan Bishop.
I'm sorry, the last name is what?
Bishop.
Bishop.
Yeah, I know a Nathan Lane.
I thought you were calling the actor.
It would be impressive.
I think we're going to need to start calling.
basis. I'm sure it's already read. Ladies and gentlemen, we're going to take a break. We're going to take something up with you all back in the jury room. Again, don't discuss the case while you're in the jury room. Do not form or express an opinion. Okay? We'll see you back in just a few minutes. All right, let's be seated. I think the objection is foundational. Let's go ahead and see with the jury out whether a foundation can be established so the court can rule.
Do you solemnly swear the testimony you're about to give to be the truth, whole truth, and nothing but the truth, so help you God?
I do.
You may be seated.
Go ahead, Mr. Taylor.
Are you Nathan Bishop?
Yes.
And back in October of 2011, how were you employed?
I was with the TBI.
Could you mind scooting up a little bit more?
I was with the TBI.
And what was your relationship to Dyer County with the TBI?
I was a field agent assigned primarily to Dyer County and Lake County.
Now, pursuant to your duties, did you become involved in a search of the David Swift home?
Yes.
Did you obtain the search warrant for the home?
I obtained a search warrant for one search of the home.
All right. Was that, I guess, early on in November of 2011, to your recollection?
I think so, yes.
And did you receive, I know it's been a long time, you weren't called by the state as a witness in this case, correct?
I was subpoenaed by the state, yes.
Okay. Did you go with a team to execute the search warrant in November of 2011?
Yes.
And if the date on the search warrant is a specific date, is that, and your signature's on it, is that the date that you participated?
Yes.
Okay. And did you receive materials to review regarding this, what you did with the team on the search?
I'm sorry, I don't know.
Did you go with a team of others to examine the Swift home when you executed the search warrant?
Yes.
And did you and this team, was there several members of this team?
Yeah, it was a standard violent crime response team, approximately 6 to 7 people, maybe.
And what do they do when they examine this violent crime unit?
Usually the procedure is that the agent, and at this particular time, Investigator McCright was with me. We went in and had the occupants of the house leave and cleared the house to make sure that there was no threats to the violent crimes team. I would have done a walkthrough with the leader of the crime scene team, just walk through the house and answer any questions that I could, and turned over the scene to them.
And who was the leader of the team?
I don't recall his name.
Okay. And were there several members of the team?
Yes.
And did you stay at the house while the team examined different things in the house?
Yes.
And did this take several hours?
Yes.
Did this result in swabs and pictures and examination of a lot of the house and the area around the house?
Yes.
And from that were pictures and swabs and things taken.
Yes.
And were they gathered by the TBI team to process and determine whether or not they were important to the investigation?
Yes.
And once the team completed their examination, Did you stay the entire time?
Yes, I believe on that particular occasion. If I could see the search warrant.
Okay. Did you examine some documents that were sent to you to determine if that was a copy of the report that was issued in that situation?
In the documents, yes, I did.
All right. Would the search warrant be helpful for you to look at?
Yes, sir.
Pass that.
State needs to see it first.
Oh, yeah. Yeah. Just want to pass it to refresh his memory.
Yes, this was Judge Childers. He came to the scene, reviewed the evidence, and we did the return on the spot.
I believe the question, Mr. Taylor, was did he stay the entire time? And that's when he asked to examine his search warrant. So it's in a narrative, open-ended narrative here. I'm trying to authenticate documents. I don't want to know about the rest of it.
I didn't intend on introducing that, Judge. He asked for it to refresh his memory.
Right.
And so,
if he has, then let's let him answer your question.
Does that refresh your memory?
Yes.
And did you obtain a search warrant in that situation?
Yes.
On that date?
Yes.
And is that a true and accurate copy of it?
Yes.
Okay. And if I could have that back. Thank you, sir. Was a report prepared after the team came and searched the home and tested and examined the things?
Yes.
Is that standard procedure?
Yes, it is.
And was a report prepared in this situation from that date?
Yes.
Did you have a chance to, just one second. And did you, I guess, as case agent for Dyer County, did you keep a case file on this case?
It wasn't a TBI investigation. It was an assist, but there was a case file, yes.
And did you maintain that in your office or with the TBI?
It's on the TBI database.
And did you have access to it and could consult with it?
Yes.
Can I pass this?
Can we clarify which question he was answering yes to?
About the report.
He said access and consult with it.
Access, could you look at it online if you wanted to and review it?
I could, yes.
And if I could pass this to witness.
Did you say online? Could you look at it online?
I'm sorry, I was inartful.
Well, he said yes to it.
Yeah, but let me clarify.
Okay.
How did you look, if you wanted to look at the case file, was it a paper copy or just tell us how you could access it?
If it's a TBI document, I could log on and review it as the case files would be in a secure server. Log on and look at it that way, or I could just go to Mr. McCray and look at the paper copies.
And we've just passed you something. Would you look at that for just a moment, just review it, refresh your memory?
Okay.
Does that appear to be an accurate copy of the report that was issued based on that search and examination?
It appears so, yes.
And did you have a chance to look through and review various diagrams and drawings that were made? Is that part of this report?
It is part of the report.
Is that part of standard procedure when the TBI goes in and examines someplace that they take detailed drawings and examinations?
It is.
Is that to have a complete investigation?
I'm sorry, I didn't hear.
Is that to have a complete and thorough investigation?
Yes, it's to document the scene.
And could that involve a record of everything that they look at or examine or swab or take pictures of?
It should, yes.
The report that you're given, again, that's a true and accurate copy of the report that was issued as a result of that examination and report.
It's a report that was issued by a crime scene forensic scientist, Kevin Warner.
And did you assisted that team and you were present during the entire time that they were there?
I was present, yes.
Yes. And you were the TBI agent for Dyer County that assisted them when they did that?
Yes.
All right. Judge, I just submitted it's a true and accurate copy of a report that's prepared in business.
Let's let the state cross-examine and say.
Okay. Now, I believe you testified that once you did the initial walkthrough and ensured the safety of the team, you got out of their way and let them do their business?
That's correct.
Okay. I'm going to hand you a page. Okay, do you recognize the form of that document? I'm not asking if you recognize that particular document.
Yes, I do. It's a TBI crime scene evidence log.
Okay, and as you go down, it starts an item number, and then it goes over location, description, gives a date and a time and a collected by.
That's correct.
Okay, so on number 1, would you read what it says?
Item number 1, paperwork from passenger seat rear pocket, 11:10:11, 5 p.m. KRW.
Okay, now who is KRW?
I don't know right offhand, but it was a member.
Did you watch KRW retrieve that item?
No.
Okay, would you hand me the... Oh, wait, hold on one more second. Hand it back to him, please. Could you please scan the rest of the page? Do you recall seeing any of those items recovered by any of the agent's initials on the page?
I recall the items, but not who actually recovered them.
Can you testify that you recall that or that you assisted with that agent in recovering each particular item?
No.
Okay, I'm going to have that back. Another document. Can you tell us what that is, sir?
That's a crime scene sketch of 65 Willie Johnson Road, Dyersburg, Tennessee.
Okay, and are there measurements on that document, sir?
Yes, there is.
Are there items listed as being found in certain locations?
I don't see a description of anything on here.
But on that one, are there measurements?
Yes, there is.
Did you take those measurements?
No, I did not.
Did you assist in taking those measurements?
No, I did not.
Can you testify to their accuracy?
No, I cannot.
No more questions, Your Honor, regarding this issue.
Anything else, Mr. Taylor?
In this report, it has the work of several individuals that were on the team.
That's correct.
And you were with the team.
I was present at the house, yes.
And
Let me ask, what do you mean you were with the team?
you were present at the scene. At the scene is my inartful, I guess, question, Judge.
No, I just want to be clear what you were asking.
You were present the entire time the team was there.
Yes, I was at the residence the entire time that they were working there.
And you didn't personally do everything.
No.
And it's normal that they take measurements and they examine things and they take swabs, things that were done in this report.
Yes.
And afterwards you had a copy, or I guess you can testify that that is a correct copy of the compiled report that was done in the investigation that you assisted in, because you're the TBI agent in Dyer County.
Yes, that's a standard report.
Yeah. All right. That's, I guess, basically all the questions I have of him.
I need to see the documents that you're wanting to get into evidence.
He has those right there.
You did not, when we had bench conference, you didn't have the full report. You just had
I had part
some
of it.
documents that you wanted to get in.
The diagrams.
Okay. Just the diagrams? Those just the documents you cross-examined him about?
Well, just a sampling of the documents that I just, what I cross-examined him about was a sampling of the documents that are attended.
Okay.
Judge, they write down, they took all kinds of pictures, and some of those pictures have been introduced of these items that are mentioned. It's the report that just shows where they were located. Now, some of these have been mentioned or testified in the state's proof, but it shows that an investigation was done and what they examined. And I just believe that it's important to show exactly what was done. And it's a true and accurate copy. We have a right. Usually when we have a case, the state presents investigators that explain what was done in detail about the examination of the items of the house. That was not done in the state's case in chief, and I'm just saying it as a fact. And the chief investigating officer said he was there when they did it, but didn't watch them and didn't know what they said. I believe that's what I recall. You decide what you remember, Judge. But it is important to show, and the due process rights of my client allow us. The government's not saying, I believe, that it's an inaccurate report. Their objection is to foundation. Now, it's the report that we received from the prosecution. And I just believe that due process should allow, he's testified as a true and accurate copy of the report. He's the agent assigned. It does demonstrate just what they tested. It doesn't there say what their testing results are other than what these TBI agents have already testified, but it just talks about what they looked at when they went through the house. It's not in controversy that they went through and examined the house, Judge. And just to thoroughly represent my client and protect his rights under due process, I believe I have the right to show that a very thorough investigation was done in more detail than what's been presented by the state.
Thank you.
That's why I'm doing it.
I understand your argument. The court's obligated to follow the rules of evidence in the authentication presentation of any document. The court's looking at rules 901, 902, 903 as far as authentication of the documents. I'm looking at the Tennessee Bureau of Investigation report. I don't know what all pages there.
I'm primarily concerned with the diagrams that show where they found things, Judge.
I can't really tell what the date of the report is, but it reflects a
it is written on later.
Search of the scene on November 10.
The report number, I think, probably reveals the date, 11/10/17/457. Agent Bishop was present at the scene. During the time of the examination of the property involved there, the case file, the report was located in the case file, which was accessible to Agent Bishop, as well as the court has to assume any other authorized Tennessee Bureau of Investigation personnel. He had the ability to review it along with others there. The document does not, the best I can see, does not purport to bear seal of the state of Tennessee, nor any sort of certification there. Agent Bishop did not testify that he is the records custodian for the Tennessee Bureau of Investigation. He did not assist with the recovery of items listed in the evidence log, did not assist with the measurements of the home interior or exterior. There's no proof that he supervised the search. The court just does not believe that an appropriate foundation has been laid for the document, and so the report and its contents will be excluded.
Judge, can I say one thing for the record, and then I'll be quiet?
You say whatever you want to for the record.
Yes, sir.
Okay. Go right ahead.
I would liken it to, or compare it to, the fingerprint examination that was done. This fingerprint officer that just testified indicated that she received an item from the Dyer County Sheriff's Department of fingerprints. They did not.
What would be the purpose when you say you want to compare? What do you want the court to look at the documents? You want the jury to look? What are you trying to accomplish? Let's kind of get to this, because I'm not going to go off on a tangent.
Yes, sir.
With that, I mean, there was no objection to your witness who testified about the fingerprints. There is an objection to this witness being the qualifying, authenticating witness for this report. The court's ruled on that. They're two separate matters. Okay.
It's sort of like relying on the work of somebody else to compare something else. And so I'll just state that for the record. And I understand Your Honor's ruled against me. I will state I received this today before trial. I did not have the opportunity to subpoena the officer because he's retired. And I subpoenaed every possible TBI agent on the list months ago, including Bishop. And his name's in the report. I didn't receive the report. And so it was introduced in the evidence, and that's the reason why.
Okay. Are we ready for the jury?
All rise. All right, let's be seated. Sir, you've already been placed under oath. Okay.
Yes.
Go ahead.
Are you Nathan Bishop?
Yes.
And how are you employed now?
I work in programs at the Dyer County Sheriff's Department.
And were you previously employed by the TBI?
Yes, I was.
And how long were you employed by the TBI? How many years?
I was with the state 22 years.
back in November of 2011, were you employed as a TBI agent?
Yes, I was.
And where were you assigned?
Primarily to Dyer and Lake County.
Pursuant to your duties as a TBI agent in November of 2011, did you become involved in an investigation or search warrant at the Swift home?
Yes, I did.
Did you obtain a search warrant for the Swift home on November the 10th, 2011?
Yes, I did.
And would you just briefly describe, once you obtained the search warrant, were there other TBI agents that were involved with you in executing the search warrant?
Yes, there was. I would have recalled my supervisor, who was at that time, I believe, Jack Van Hoosier, and requested the violent crimes response team.
Who exactly, what does the violent crimes response team do?
They're a team of special agent forensic scientists who come to violent crime scenes and process the scene by obtaining evidence, searching.
And do they examine the area to be searched and do tests or take photographs?
Yes, they document the scene thoroughly.
And on November the 10th, 2011, when this search warrant was executed, did you and this team go to the Swift house?
Yes.
And did you enter the Swift house?
Yes, I entered before the team.
And I guess what was your purpose?
I would have gone in, I believe Investigator McCright was with me. We would have asked any occupants in the house to leave, and we would have did a walkthrough and make sure that there was no one in the house or any dangers to the forensic scientist.
Now, the occupants, would that have been David Swift and his children?
Yes.
And did you ask him and his family to leave the house so you could do this search?
I did.
And did the team come into the house and onto the property of the Swift house on that occasion?
I'm sorry, could you repeat?
Did you and the team go in and execute the search warrant and do, test and walk through the house?
I would have done a walkthrough with the team leader on this one, and after that I would have turned it over to the violent crime response team. They would have done all testing and everything else.
Now, would they have done that while you're present at the house?
I was present the whole time, but not present during each individual item.
Now, would you have occasion to have walked through while this team was there and see that things were going on in the house while you were there?
Yes.
Would the investigator from the Dyer County Sheriff's Department also have been there?
He was present at the scene, yes.
And would you have stayed until the team was completed with their work?
Absolutely, yes.
All right. Would this have taken minutes or hours?
It was hours.
And while you were there, I understand you didn't watch everything that they did. Is that correct?
That's correct.
But did you see them either? What did you see them doing?
I saw them going about their usual routine, which would have been photographing, looking for pieces of evidence, searching. I recall one piece of evidence in particular, but...
And if it was something that this team deemed important, would they have taken it?
Yes.
Or would they have photographed it?
They would have done both.
Or would they have swabbed it?
They could have.
Okay. And is there anything else that they could have done? They had free reign, I guess, to take samples and testing.
Yes, they did.
After the hours of this search, was this in the interior of the home or the interior and immediately around the home? You know, like the immediate yard of the home?
It was the interior of the home, the exterior of the home, a vehicle. So.
Okay. And do you recall which vehicle it was? Or?
I believe it was a Volvo belonging to Mr. Swift.
And was examination done of that vehicle?
It was searched, yes.
And this team had access to it?
Yes, they did.
And it would have also included the property around the house, like
yes.
the yard? At the conclusion of the team's work, did Did you stay through that?
I'm sorry.
Did you stay till the team was completed with their examination of the house and the property?
Yes, I did.
And was that several hours later?
Yes.
And then after that, was documentation made of what was found or what was observed?
Yes, I would have done a return on the search warrant.
And would this team from that search, whatever they recovered, could that have been used for testing, later testing and examination?
Yes.
All right. And would a report have been prepared showing what the... I'm just asking, I'm not asking what's in it, but would a report have been prepared?
I think it's a fair question. Objections overruled.
Yes, it would have been normal procedure for the forensic scientist to do a report.
And would it have been a detailed report?
Yes, that's routine.
All right. And was that done in this case?
Yes.
All right. That's all I have with the officer.
You step down, sir. Thank you. Ladies and gentlemen, we're going to go ahead and stop here for the evening. We think we're at a good stopping point, and my 8 o'clock experiment was probably not the best call. You won't hear somebody admit that very often. We'll go back to 8:30 tomorrow morning there, and we'll resume with the case. You know, I've got to tell you the things that we always need to talk about. Please don't discuss this case with each other or with anybody else Do not speak with the attorneys, the defendant, any family members of either the defendant or the victim, or any person who claims to be a reporter or a media professional. You may not give an interview for any reason, under any conditions, including being an unnamed source, or promise not to publish the interview or the information until after the trial. Do not form or express an opinion about the case. Again, do not read, listen to, or view any news reports, social media posts, or the playing of the trial there. Don't post anything on social media or an internet site. Don't let anybody do that for you as well. Again, we're going to get to the end of the proof in this, and you all are going to decide this case on the facts that you've heard in the courtroom and the law that I'm going to give you. Don't do any research tonight, or visit places, or try to locate them on a map so you can kind of get an idea. That's not permitted as well. I hope you have a great evening, and we'll resume 8:30, hopefully 8:30 sharp in the morning. Okay, thank you all. All right, is there anything we need to do before we adjourn for the evening? Stay? Okay, 8:30 in the morning. Thank you, guys.